This court is not in a position to grant any relief to the petitioner. The petition is dismissed.
Lordship, I beg to mention item number 15. Allow us 4 weeks time to file our receipt.
Item number
15.
15.
Yes.
Here for whom?
For DSC.
CGST.
Yes, sir.
Inform the other side.
I'm for the other side.
Okay. We grant 4 weeks time
Lordship.
on the prayer made on behalf of the respondent GST, 4 weeks time is granted for filing affidavit in opposition.
Interim to
Interim order passed earlier to continue till the next date of listing.
oblige.
Highly.
Wait, please, Lordship.
Yes.
Lordship, I beg to mention item number 10 of this daily list. Lordship.
Yes.
This matter, my lord, we have to file our affidavit. We have sent it for signing and waiting, Lordship.
Inform the other
Therefore,
side.
I am for the petition. I have informed the other side. I am for the petition.
Okay.
So after the vacations, your lord.
Okay. On the prayer made on behalf of the GAD,
But-
matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Yes. Is there any interim order?
No, Lord.
I go to the interim order till the next date. Listen, I got it till the next date of listing.
DPF.
Oblige.
May please, your Lordship. Item number 4.
Four.
May be adjourned for to and list after that.
Kalyan Bhattacharya,
Okay.
on a prayer made on behalf of the petitioner, matter is adjourned to be listed after the Bihu vacation. Yes,
May please. I beg to mention item by 11 matter.
yes.
I'm mentioning on behalf of respondent number 5 matter. I feel that this matter will be passed over to the day matter. I have taken the concept from that side.
Yes, Mr. Chakraborty, you are there.
Yes, my lord. I'm for the petitioner. There is an
Okay.
interim order, my lord.
Okay.
That's why kindly people.
Okay, on a prayer made on behalf of the respondent number 5, matter is adjourned to be listed after 2 weeks, full stop. Interim order passed earlier, stands extended till the next date of listing.
Oblige.
Wait,
Yes,
Lordship, I beg to mention item number 5 from today.
yes.
My senior is unwell. So the matter may be adjourned for the day and taken up.
Who is your senior?
Be seen now.
Okay. It is submitted that Sri B. Sinha, learned counsel for the petitioner, is unwell. Full stop. Para. List after 2 weeks.
Deeply utilized.
May please, your Lordship. Lordship, I beg to mention item number 1, Lord. Lordship, counsel of the petition, Lordship, now out of station, Lord. On telephone inspection, I am appearing on behalf.
We can issue notice, perhaps this is a contempt matter. What is the requirement of a counsel? Okay, let it be after the, it is submitted. That's Sri J. Laskar, learned counsel for the petitioner. He is out of station, full stop. Para. List after 2 weeks.
May please, your Lordship. Lordship, I beg to mention item number 13, 1-3 of
Yes.
today's daily list. Lordship, the arguing counsel is out of station. We have taken the consent of the other side. Can it be taken up after 2 weeks?
Okay. Item 13, on a prayer made on behalf of the respondent. Matter is adjourned by 2 weeks.
Not Lordship.
May I please, the Lord. Also, item number 12 of today's daily. Also, in this matter, we will file affidavit in reply. Affidavit
You're
is
for the,
almost
you're
ready.
for the petitioner.
I'm for a petition.
Okay. On a prayer, Anna, what is your name?
A. Ahmed.
Sri A. Ahmed, learned counsel for the petitioner submits that rejoinder affidavit would be filed for which he prays for time. Full stop. Para. List after 2 weeks
2 weeks.
to enable filing of rejoinder affidavit.
Deeply okay.
Okay.
Item 2.
Item 2, Lordship. We have been directed to obtain instructions and we have received the instructions. Lord.
Yes.
May I place it before Lord?
Yes, please. এখন ফাইল আপ করে দিব ওটা কি তো ফাইল ঠিক Yes.
encroaching the Sorusala bill, Lord.
Has the speaking order been passed?
That is
Has any speaking order been passed? In the first order,
Yes, yes.
18/3/2024, there was an interim direction for maintenance of status quo till passing of a speaking order.
But in the report, Lordship, there is no such any reflection regarding the speaking order. But the report, Lordship, page 3, that is the report of the circle officer in vernacular.
Hmm.
Third page, Lordship.
Hmm.
This is a letter issued by the circle officer to the district commissioner, additional district commissioner. This is the report, Lordship.
No, have you
But
gone
that-
through the order of 18/3/2024? You have. See, towards the last part, it has been listed today, and the observation is that considering the fact that there was already an order for maintenance of status quo
Yes.
till passing of a speaking order, and a specific stand that such speaking order has not been passed till date is taken, it is provided the respondent shall not give effect to the impugn notice.
Right. But regarding the speaking order, there is no such reflection in.
Yes, you just get whether speaking order is passed or not. Heard.
My lord, notice is not issued. Lordship may please to issue notice, my lord, in this matter.
No, these are matters of
The urgency is there, Lordship. Let it be in the motion stage itself.
public land.
Lord-
We will just give a. If you make out a case, there's a matter is different. Heard Sri B.K. Das, learned counsel for the petitioners. Full stop. Para. It appears that this court, while considering this matter on the last occasion, that is 18/3/2024, had directed obtaining of instructions with regard to the aspect of passing any speaking order which was the direction passed in the earlier proceeding initiated by the
25,
initiated by the petitioner being WPC 1489 of 2014. Full stop. Para. Sri H. Sharma, learned additional senior advocate, though has produced certain instructions, specific instructions in the regard as to whether any speaking order was passed has not been obtained. Full stop. Para. Considering the gravity of the matter, which is connected with the Sarusala bill. Where is it? Sarusala bill?
Rehab area, my lord.
Horusola bill, that
It is called Horusala bill.
Horusola.
Horusala bill in the heart of Guwahati, in the heart of the city of Guwahati, let the matter be adjourned to be listed. Let another opportunity be granted to the learned state council to obtain specific instructions in that regard. Full stop. Para. List on today is 10th. We'll have it on 26th.
Lordship, Lord,
We have given 26 because of the intervening Bihu holidays.
Lord.
Get the instructions.
Lord, one more submission matter.
The
Please,
interim order passed earlier.
Yes.
Stands extended till the next date of listing.
my lord, there is a LIC report, my lord, to my lord, allotment of the land, my lord, to take instruction on that LIC report also, my lord, page 24, my lord.
Let us first have the
Yes.
speaking order.
My lord. Obliged.
Mr. Sharma, you can take this back.
Item 3.
Yes.
It's similar regarding highway land. Our land is side by the highway, my lord. But they have not acquired our land, as because this will not Pakistan. And but there is a house, standing house, and Tiras and also on Monday, my lord. But that, my lord, they have given notice, my lord, we have to vacate
This
it.
is the instruction, Lord.
And earlier, before that, my lord, we also appear earlier, my lord, before the court, my lord, and this court was directed, my lord, that we are in detail for the Jirat.
What is your instruction? What do you say?
Lordship, they have, the right of way has been. What do you call it, which petitioner is claiming.
Now, have you
Which-
made any assessment towards the claim for
Yes, yes, the
Jirat
acquisition
compensation?
procedures has also been started, Lordship, under the National Highway Act 1956.
No, have you made any assessment towards the claim for
Regarding the
Jirat
Jirat
compensation?
Jirat, Lordship. Yes, Lordship, in the last part of paragraph 3, Lordship.
Of your instruction?
Lord.
Second page.
Not the first page, last line. The Honorable Guwahati High Court further observed that the petitioner would be at liberty entitled to Jirat compensation if there is any structure constructed by the petitioner on the state land standing crops belonging to the petitioner. On being perusal of the 3A and 3D notifications were also directed to be.
On being perusal on perusal of so and so, it is seen that doc number so and so under so and so against the petitioner is claiming
This
Jirat
paragraph 4 is
are not
important. Lord.
are not notified.
Yes, as it is already
already
acquired existing land of national highway.
No, my instruction is, my lord, that they have not instructed, acquired our land, my lord, and they have given notice, my lord, to vacate. And that notice, my lord, under before lordship. Page 27. my
No,
lord.
if the instructions are to be taken into consideration, it says that the concerned land has already been acquired, not by this proceeding, earlier by the as existing land of national highway.
National highway.
366 million, I have one TI million filed by someone. I have a copy million. I need
Page?
no, I don't have not the next million.
Page 66.
6 million. No. Subsequently, I have got million. Kindly see only this million. You lost million.
What is the, you read it out?
RTI was filed million by someone, and then they have replied. The doc number million 366 of Billis Agia part 2 Lubara revenue number so is not required in 3D for ordaining two land road.
This paragraph 5, Lordship, last
No,
line.
there is no question of acquiring again. That is the instruction. It says that the notification under section 3A or 3A and 3D gazette
3D,
notification is not concerning this particular land because it was already an existing acquired land.
Required. But in my instruction,
next-
my lord, that land has not been required.
You are still in possession of the land.
Yes, my lord.
If it is, Mr. Sharma, if it was acquired earlier, you produce those information.
Yes, ma'am.
When was it acquired, by
But-
which, in which case? I think you should file an affidavit.
Affidavit, Lord.
And this is the my lord, the RTI reply filed by the authority, my lord, stating that their land was not acquired till date. And that
You
reply
also,
was given, my lord,
you can bring that on record by way of
my
addition.
lord, yes.
Hearts V. A. Rashid, Learned Counsel,
Till then, my lord, it may be.
petitioner. Full stop. The claim of the petitioner is that he is residing on a plot of land by constructing an A-type house with boundary wall and other structures and certain trees. Full stop. It is the specific case that the land in question has not been acquired for NH, for the national highway, whereas land of other people has been acquired. Full stop. However, comma, there was a move to evict the petitioner, for which the petitioner had earlier filed in WPC 5060 of 2023. Full stop. In the said writ petition, comma, it was observed that if the petitioner is entitled to Jirat compensation, comma, the same is to be paid. Where is the court's order?
Page 25, my lord. It is from 23, 25, my lord, 11%, paragraph 6 and 7, my lord. Order by Honorable Justice, my lord,
6 and 7.
Purva.
Your projection is not correct, Mr. Rashid. Paragraph 7 is something else.
Of the order.
Judgment,
No, of my petition, my lord.
yes.
By
No,
that,
not your petition,
By
of
this
the
paragraph
judgment.
7, we can directly write with, we can evict it,
Yes.
evict them, Lord.
কি করলো?
Yes, my lord.
Oh.
Earlier, my lord, they can, before filing a direct petition, my lord, yes, they can, my lord.
Wait, full stop, para. The aforesaid projection, however, does not appear to be a correct projection in view of the observations made by the observation oblique directions made by this court in the order dated 1/9/2023, passed in the aforesaid writ petition 5 WPC 5060 of 2023, which reads as follows, page 25, paragraph 7, full stop, para. It is contended that the petitioner is still in possession of the land. Full stop, para. Sri H. Sharma, Learned State Additional Senior Government Advocate, Assam, has, however, obtained written instructions as per which, comma, the land over which the petitioner is claiming Zirat compensation was not within the ambit of the notifications 3A at asylum, 3A at and 2 and so and so, as it was already acquired, as the same is an already acquired land of the national highway. Full stop, para. Let notice be issued, returnable by 4 weeks. Let Sri Sharma, the London State Council, accepts notice on behalf of respond numbers 1, 2, Mr. Sri Sharma accepts
2, 3,
notice on
4.
behalf of respond numbers 2, 3, and 4.
Sure.
Whereas Ms. G. Hazarika Learned Standing Council Revenue accepts for respond number 1. Full stop. Sri Bora, Learned CGC. Okay. For accepts notice on behalf of MSR Bora, Learned CGC for responders 5 and 6. Let extra copies of this writ petition be served upon the Learned Council for the respondents. Para. By the returnable date, let the instructions be placed on record by way of an affidavit. No, don't say that. By the returnable date, let affidavits be filed, putting on record all the relevant facts.
Sure.
Do you have a copy of this?
Lordship,
Yeah.
that may be kept in
Okay.
court.
It will argue about the second page.
Lordship, may I pray for a fixed date, Lord?
list on 3rd of May.
My favorite in 3 minutes, till then,
Interim, we are not passing any. Last-
till
In
then.
fact, this writ petition, we are doubting whether it's maintainable with the same cause of action.
No, I'll
After
file
that paragraph 7 of the
I also
order.
file additional 3 minutes on that point. of RTA.
The petitioner is also at liberty to file additional affidavit.
And till then, my
Correct.
most.
Item 6.
Wait, please, Lord. In this case, my lord, the respondent number 6, my lord, without having its existence, my lord, occupied a land of my lord, huge portion of land, my lord, belonging to various my lord, groups.
Respondent number
Include-
6 says,
The my lord, Puronimati Stipam Samavais Committee, my lord.
what they have done.
They have acquired, my lord, 400 bighas of land, my lord, meant for fishermen, and as well as the petitioner's good fine, self-help. Though my lord, application was submitted before the deputy page 20, my lord, make an inquiry, but nothing has been done till date.
What is your right over this land?
My lord, we belong to my lord fisherman group, my lord.
No, what is your right over the land?
My lord, we have been allotted with some land, my lord,
Where?
by the authorities, my lord.
Where?
There is no letter is my lord could not be produced, my lord, since the authority has not provided all those documents. Page 20, my lord.
20,
Yes, my
20.
20. Representation, vernacular page
Representation will
20,
not do. You have to show some semblance of right over this plot of land.
my lord.
By simply saying that I am the owner will not do.
Right.
There has to be some documents of settlement or patta or maybe tozi, whatever, that you are in possession or you have some semblance of right.
Right.
You don't have.
My lord, we are submitting application on the RTI, my lord. They are not providing all those documents, my lord.
That will not be enough.
Then some time may be given, my lord, for this, my lord.
You have to incorporate documents.
Right.
Unless you incorporate documents, there is nothing for us to, which will lead us to entertain this petition.
My lord.
Heard Sri P.J. Sekia, learned counsel for the petitioner. Full stop. The also heard Miss M.D. Bora, learned standing counsel, cooperation department, full stop. Para. The allegation in this petition is that a large plot of land measuring about 400 bighas has been allotted in the name of a non-existent and fake Samabai Samiti, which has been full stop. Ironically, comma, the non-existent within inverted comma and fake inverted comma Samabai Samiti has also been made party respondent number 6. Full stop. The petitioner has not been able to show any materials or annex any documents towards the claim over the plot of land. Full stop. Para. In absence of such materials, comma, it will not be proper on the part of a writ court to entertain petition of this nature. Full stop. Para. Be that as it may, and in the interest of justice, comma, the learned counsel for the petitioner is granted 3 weeks' time. The learned counsel for the petitioner prays the prayer at this stage, comma, Sri P.J. Sekia, learned counsel for the petitioner, prays that he may be allowed to file additional affidavit with supported with documents which would support his case. Full stop. Para. In the interest of justice, matter is accordingly adjourned by 3 weeks to enable filing of such additional affidavit.
I'm aware.
Item 7.
May I appeal that? My lord, petitioner has been deprived from the listing out the on crop which he had been running with effect from 99 to
2008 to June 2023. Now new construction has been done. There new rooms are going to be allotted, but the petitioner has been deprived from the state group.
Rooms will be given on what basis?
On rent basis.
No, rent we know. Who will be given? How do you select
That
the
is-
allottees?
Yes, that is as per section 62 and 148 of the Assam Municipal Act. There should be tender process is etc. But without doing this all these methods they are
Where have you stated?
yes, but we have stated paragraph 13
1-3.
once.
Yes. Yes, please.
That the petitioner have expressed that the Sapulgram Municipal Board, Sapulgram is contemplating to allot 21 numbers of rooms to the first person within a week without any tender process in gross violation of section 62 and 148 of the Assam Municipal Act 1956. And
Yes,
as per-
who would be appearing, madam? You would be appearing for whom?
Basis of its allegation. So it's not known, nevertheless, my lord, I'll look at it.
Okay. Who would appear for Municipal Administration Department?
I-
Yes, you'll appear. Okay. Okay. Heard Sri M.U. Mandal, Learned Counsel for the petitioner. Full stop. The case of the petitioner is that he is running a shop in a room at the old bus stand under the Sapatgram Town Committee from the year 2008. Full stop. In June 2023, the said structure was demolished and for the purpose of building a new structure. Full stop. It is the case of the petitioner that in the fresh allotment process, he would be deprived of such allotment and the same has been, and the apprehension of the petitioner is that the same is being allotted to 21 numbers of persons without any prescribed procedure. Full stop. Para. That notice be issued, returnable on 3rd of May 2024. MS S. Sharma, Learned State Council, accepts notice on behalf of
1 to 5.
respondent was 1 to 5. I think 4 or 6 also you can.
6 also.
1 to 6. That extra copies, huh? When can you serve extra copies? Today?
Today.
By today? Last steps for service of notice upon respondent number 7 be taken within a week from today. Full stop. Para. Sri Mandal, Learned Council, prays for an interim order. Full stop. Interim order to the extent that the 10 numbers of room in the backside of the new building at old bus stand under Sapatgram Municipal Board may not be allotted. Full stop. However, this court is not inclined to grant the interim order as paid for. Full stop. Nonetheless, it is directed that any allotment made has to be preceded by a recognized procedure established by law. If it is done by tender, we cannot.
One room kept, otherwise the entire room
If it is done by tender, you participate.
public sector.
With your lordship. My lord, the
Yes.
Assam Board of Revenue has refused to my lord, counter a delay of 220 days in filing a review application against the order.
Review application. What is the prescribed time, period of limitation?
My lord, prescribed time is, my lord, 30 days.
30 days. What is your explanation? What was your explanation?
My explanation was that, my lord, the gentleman who is about 85 years old, my lord, he mostly stays in Rajasthan. And my lord, he also filed a writ petition against the order. Then this honorable court, while dispositing writ petition, given him liberty to file the review application. And he filed the review application. There was that. At this stage, my lord,
How long did the writ petition take in this court?
my lord,
The writ petition was pending in this court for how long?
writ petition was, my lord, filed page 87, my lord. Because of age, my lord, the gentleman speaks different. It's a
See, this
different
writ petition was filed in 2022
Yes.
and 2022, it was dismissed.
Yes.
Now 22 to 24, that I think will not have any bearing, that writ petition part.
That is right.
Okay.
But the gentleman is not here, my lord. Primarily, that was the reason.
Okay. We'll issue notice,
Yes, my
madam,
lord.
at this
Okay.
stage. Heard Sri M.K. Chaudhary, learned senior counsel for the, assisted by Sri M.K. Bora, learned counsel for the petitioner. Full stop. The instant petition has been filed against
It's been ordered
an
that-
order dated 9/1/2024 passed by the learned Assam Board of Revenue within bracket ABR, whereby the application filed for review of an earlier judgment dated 6/5/2010 has been dismissed. Full stop. How much is the delay?
228 days.
It will be much more.
That is what was calculated by the
No, if it is 2010 judgment,
No, my lord, the last order of the ABR is at, my lord, page 57, that is
21/12.
December 21.
21/12, 21, no, I don't know. What was 6/5 then?
My lord,
What was 6/5/2010?
2010 is, my lord, the earlier.
Okay, dated 21/12/2021. Full stop. It is submitted that though the review has been dismissed on the ground of limitation, comma, there were sufficient reasons which were not taken into proper consideration by the learned board. Full stop para. The matter may require some scrutiny. Full stop para. Let notice be issued, returnable by 4 weeks. Madam, you take for ABR? No. For
Yep.
Assam Board of Revenue, will you take? No.
No, but it's like open
le-
except
uh,
for box.
Ms. S. Sharma, London State Council accepts notice on behalf of respondents 2, 3, and 4. Let step extra copies. Can you serve today?
Yes, my
Let extra copies be served during the course of the day. Let steps be taken for the respondent numbers 1, 5, and 6 by registered post with AD. Steps within a week.
highly applied.
Item 9.
May pleasure.
Mr. Fukan, what is this?
The petitioner is aggrieved, lordship, by the election on part of the respondent authority, lordship, in deciding the compensation amount. Against the,
Compensation for what?
against acquisition of land under Assam Mala project, lord.
It has not been assessed.
Assessed, lordship, but my lord, the petitioner has raised objection regarding the compensation amount. And
You want more compensation.
lordship.
So there is a procedure prescribed.
Yes, my,
Why don't you go there? How can we?
one
You
thing
may
I-
be correct that the assessment is inadequate. but the matter regarding adequacy, sufficiency are not within the ambit of a writ code. It's a self-contained code. You approach that authority.
In respect of my lord, petitioner concern, paragraph 5, it is mentioned that already 25 lakhs has already been deposited by the requiring department. To that extent, unless and until he signed the form B, my lord, whether.
No,
what
see,
the
we
procedure
are
is
not,
there.
madam, we are not really concerned about the amount. It may be a huge area.
Right.
But we are concerned that whether the code under which the acquisition has
Yes,
been
sir.
made
If he is
provides for
disagreeing,
an
then
opportunity.
Question will follow.
Yes, that there is there.
17.2 is there.
Actually, the matter is required to be placed before the district level purchase committee. That has not been done yet.
Have you filed your application?
I have submitted numerous
No,
representations.
no. Suppose tomorrow we allow your writ petition.
But-
What relief can we give? We'll give the relief which you are entitled even today. We can send you there to the appropriate forum. We
But-
cannot decide the compensation.
But
Hmm? Yes, under what provision? Who will decide the any grievance regarding the adequacy, sufficiency?
As per procedure, my lord, after implementation of Form A, Form B has to be signed on the part of
Have you
the.
for sign Form B?
I have to take instruction on that, whether he has consented to that extent or not. If it is consented, that process is finalized. Otherwise, it will not go for acquisition by negotiated settlement.
Okay,
It
we'll
will
have
be
it
by-
immediately after the vacation. Take instructions.
Fine.
We'll dispose
That-
this of.
I have
You also
told
take
you,
instructions.
he is
of the
disclosing that regarding signing of Form B.
We are Fukan Learned Counsel for the petitioners, full stop. The grievance of the petitioners is with regard to the compensation for acquisition of their land under the Assam Mala project. Full stop. It is submitted that representations have been filed on the aspect of a proper assessment, which has not been considered. Full stop para. Miss M. Burman, Learned State Council, however, submits that the issue raised in this petition may not be able to be adjudicated by a writ court, as the same would involve factual aspects wherein the question of adducing evidence will come. Full stop. She has also submitted that instructions would be necessary as to whether the petitioner has fulfilled the necessary formalities
Yes.
before making a claim for enhancement. Full stop para. In the interest of justice, the matter is adjourned to be listed on 1st of May 2024 to enable both the Learned Counsel for both the parties to obtain instructions.
obliged.
Obliged.
For motion, huh? Adjourn so and so for motion.
Before my friend starts, I must apply this honorable court that a connected writ petition has been listed in court number 13
Today,
today. It may not be proper in the court because there might be conflicting orders. May I pray, subject to everything, all fairness, let this matter be adjourned, listed on the reopening, we'll have it tagged because the same issue is there.
Otherwise, to mine, a copy of that petition was also served to me, my lord. To my knowledge, my lord, he has filed 2 appeal. Out of that, 1 appeal has been, my lord, decided. 1 appeal yet to be decided. So, my lord, as on that, my lord, perhaps there is no contradiction.
It is not factually correct. The order of the registrar,
the other writ petition is before which court?
court number 13, my lord
That
Justice
is-
Sumit was showing that.
That is also a bench 5 court.
It's all single benches are given there.
Okay.
Well, I'll make the next item is there. I
Okay.
will make a mention that it listed on the reopening, we'll have it tagged.
Okay, we'll have it in the
It
writ.
comes from any court, same court.
My only, my lord, prayer is, my lord, till then, my lord.
So there may not be any stay, my lord. There'll be conflicting orders.
Till then, what?
Till then, my lord, the impugn order I have challenged, my lord.
What is the impugned order?
That, my lord, proceeding of the 25-9, well, whereby the respondent number 4 was terminated, my lord, from the post of president, my lord. That order, my lord, proceeding was set aside. So, my lord,
Now
already,
you want the setting aside order to be stayed.
my lord,
Then I
Why,
have
why,
asked-
why?
Till then, my lord, on.
Why? What purpose will it serve?
Because my lord, already, my lord, new president has been elected, my lord, annual general meeting has been already conducted on 30th of September, my lord.
And I
You
can
may-
address
you
this
may-
court, I can address this court full length on this.
You,
It's not proper.
you maintain status quo till then.
My lordship, this order
No,
is,
if a new
Status quo then,
if a new body has taken over,
well, it is not there.
status quo doesn't mean that
That's a-
he will function. Nobody will function
My lord,
till the next date.
on all fairness, my lord, let both the matters come before any,
No, we'll have
anyway,
it. We'll have it.
on the reopening.
On a reopening, we'll have it.
Then I have to argue the matter there, my lord. If any order is passed on merit, I have to argue the matter.
Not on merits. We have to balance the equities.
My lordship.
If he is a elected body and your earlier order of removal has been set aside.
That is the core. That is the core. An AGM was held on 29th of September. An AGM was held.
Now,
on
what will happen to the rights which have accrued to him
I'll come to-
pursuant to his elections? Will adjudicate
that
your.
AGM, the approval was not granted. That is under challenge here. Two AGMs cannot be held by one society, my lord.
You maintain status quo.
With regard to the order dated so and so, the impugned order.
Maintain status quo.
Let us go with
You
regard to
also
impugned-
don't take major decisions.
Well,
We'll have it on the reopening.
Let us status quo with regard to the impugned order. Otherwise, things will go wrong with it. There is an order. I'm contesting on the other side.
status quo as on today.
I am contesting on the other side. There is an impugned order. Where I'm praying that the matter come up.
N.K. Kolita, learned counsel for the petitioner. Also heard Sri G. Border and Standing Counsel Cooperation
Okay, no
Department. Full stop. Sri S. Bonik, learned counsel for the respondent number 4 has submitted that there is another writ petition being
Fine.
WPC number
2094 of 24.
who has filed
I have
2094
filed. Respondent number
24.
4 has filed.
Filed by his client, which is listed today before another court.
Another court.
Within bracket, court number
13.
13, full stop. He accordingly prays for an analogous consideration of both these matters on the reopening, full stop para. On the other hand, though the aforesaid prayer has not been objected in principle by Sri Kolita, the learned counsel for the petitioner, comma, he has submitted that some interim protection may be granted till the next date fixed, full stop para. Balancing the equities, comma, it is directed that till the next date fixed, which is on 19th. We are 18th, you are opening 19th, comma, status quo with regard to the
Impugned order.
impugned order dated
21 to 24.
21,
324.
24, be maintained.
Got you.
Admission, no, go to admission. No, একটু সময় লাগবে না?
Item 25 may be taken after vacation, madam. Learned, common advocate was supposed to.
25 to vacation.
25. The review matter, madam.
Okay. এই হেৰি আনা নাই, এই মাৰাচোন। ক'লেও পাহৰি যায়। আমাৰ জৱাহৰ নোটটো কিয় নিদিম? মই ড্ৰয়াৰত থৈ দিছো কালি আধাৰ পৰা। এইবিলাকে বুজি নাপায় একো। জৱাহৰক মাতা। Yes, we'll have it. When do you want?
Take the picture.
Yes, we'll have a date. It will ask, na? Okay. What was the item number?
Item number 25. The review matter is also paper.
Yes,
please, Dr.
yes. ये बोला था देने के लिए,
At
क्यों बोल
first,
रहे थे?
I would like
कितना बार
to
बोला
place
क्यों?
before this honorable court
Just a minute, Mr. Second. 25 at a date devoted immediately after the vacation. Yes, please.
if lordship is pleased to take up the writ petition.
Yes, writ petition.
Yes.
What are the prayers? Page 39.
39.
39. Have got it.
Yes, yes.
So they want tertiary to set aside 6/6/2019.
Just a minute. 39 prayer. Tertiary for 6/6/2000. Yes.
2009, then another order of 11/7/2019, and third one is 5/9/2022.
Then so 11/7/19.
These three orders are related to constitution of the committee.
And
State
last is
level scrutiny
last
committee.
is 5/9.
5/9.
5/9.
5/9 is initially it was constituted with 6 members. 5/9/2022 it has brought back to 5 members.
And the order of 12/1 also.
12/1 is the last opinion of the SLST, where it was held that it does not belong to Boro Kochari.
Okay, there are four orders
Four
which
orders.
have been challenged.
4 order challenge, and Lordship will kindly take my additional affidavit in opposition. It's 3 pages.
By whom?
It was filed on Lordship.
By whom?
It was filed on 28th of March 2024 by respondent number 2.
Is it a rejoinder affidavit? No.
It's a additional affidavit. Lordship, we want to brought on record one very important document, because prior to this we filed a detailed affidavit.
Okay.
Here Lordship will kindly come to
Just a minute.
248.
Additional affidavit.
What is this?
Additional affidavit, we say.
Addition. Reply. R8.
It starts from 244 page number.
244. Okay, you have the page. Okay, additional affidavit in opposition.
Yes,
Okay. Yes, 245. Yes.
Yes, here we brought on record one order dated 28th January 2024, page 248.
248. Is this 28th of January? Is it 28th of January?
20th of January. Last line, last paragraph. In view the narration of the complaint and the scrutiny committee's activities.
Yes.
In view of the state level scrutiny committee hereby cancel the STP certificate issued to Nobokumar Karonia by All Assam Tribal Kongho dated 17/10/2011. This order remains unchallenged. And he received this copy on 13th of February through email in his official email address, which is nobosoronia@sangsad.nic.in. And also the private respondent, Jonoklal Bosumotari, filed a caveat on 7th of February.
No, he received on?
He received on 13.
13/2.
13/2.
Okay.
By email, he received on 13th February, and he received a copy. I do not know whether he received a copy of the caveat or not, but caveat was filed on 7th of February. And the writ petition was filed on 4th of March, if I am not wrong, Lord. 4th of March, page 42.
Caveat was filed by R8. 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 And when was the writ filed?
And it was filed on 4th of March 2024, page 42 of the writ petition. In the affidavit, they have mentioned the date as 4th March.
Okay.
So from 28th January, the order is in force regarding cancellation of the certificate. And on 4th March also, and thereafter we filed the additional affidavit which we filed on 28th of March.
Okay.
Till this moment, till date, as of now, they decided not to challenge it, in spite of getting ample opportunities for the single judges bench at the first round, and before the division bench also we highlighted this, and today again we are repeating it, the same thing. So they are not unhappy with this. So whether 12 January's opinion is set aside or not set aside, that is a different story. But ultimately, this will remain.
This is the cancellation order after this meeting.
In the interim prayer, page 41, this may be their counter. In the interim prayer, they said that opinion of that 12/1/2022 and all consequential orders issued by the authority be set aside or stay the operation. Lordship will kindly see the interim prayer. In the interim pending disposal of this request, the Honorable Court would be pleased to stay the operation of the impugned order dated 12/1/2024 passed by the SLSC and consequential orders passed or issued by the authority. So they do not want setting aside. So this is a very vital aspect which I am highlighting at the very beginning. In fact, this whole exercise will become infructuous if they do not challenge this order. And this is a specific order, Lordship. And molding of relief will not allow this Honorable Court also to went beyond this. And in support of that, Lordship, I will say to the time will be very limited. So I would like to refer to a judgment of the Honorable Supreme Court, 2011, 6 SCC, page 597. State of Himachal Pradesh and others versus Himachal Pradesh Niji Vyavasthayik Protection Kendra Sangh. This judgment has been relied by several judgments of this Honorable Court. This judgment I placed in the earlier round. So the High Court judgment I am not placing here. Paragraph 18. We'll place it on this small line. As rightly pointed out by Mr. Altaf, without any arguments having been heard, without there being any question raised by any party as to the validity of the cabinet decision dated 18/7/2009, and without the same being in question, any relief sought for in the writ petition, the High Court has gone into the state decision of the cabinet having taken place after the judgment was reserved. The decision of the cabinet generally ought not to be interfered with his judicial review so lightly as has been done in the present case. The quashing of the cabinet decision without analyzing the pros and cons in the manner seeks to restrict the state constitutional authority and power to frame policy, especially in such vital areas like imparting technical education, is not acceptable. So the law is very clear that if there is no challenge, there is no point of going into the pros and cons of that order. They cannot take the plea that we have not received it. Suppose the email was not received on 13th February. The 7 May's caveat also not. But in the additional affidavit which we have filed to them on 20th of March, today is we are standing on 10th of April. Another 20 days have elapsed and they decided not to challenge. Their basic grounds, this is the first ground. Now coming to their grounds of challenge as pleaded in the writ petition. Basically, they have challenged the writ petition on 4-5 grounds regarding constitution of the SLST as 6 members is illegal. Page 28. They have recorded about
28.
About page 28. They have recorded about 19 grounds, but basically the major grounds which they are highlighting, and there are repetitions also. That first ground, they said that legislature has not framed any laws. That is not argued, so I am skipping. Then 3 officers, 5 officers committee, they have questioned. They have also questioned the one of the member does not belong to the category of research officer on tribal affairs. I'll place my affidavit. So that was further not argued. Then deputy secretary was there in that joint secretary was not there. Then there is question of deviation from the 13.5 of the Madhuri Patil's case. Then senior DSP is not a part of the vigilance cell. In Assam, we don't have senior DSP. We have DSP and we have included the SP also.
No,
Then-
Mr. Khurshid has questioned the presence of the superintendent of police in the SLSC.
Yes, Lordship, that
when-
I'll come.
okay.
What I am trying to today, I'll argue the case from what is their pleaded case and
Okay.
what my senior friend Pursi had argued at the last. First, what is their pleaded
No,
case?
what has been pressed, you can make your response to what has been pressed. What has been pleaded?
No, Lordship, because my affidavit is very important because all the facts should be known by this honorable court. The facts
Okay.
are not highlighted at all.
Okay.
But I'll cut short. I'll not take too much of time.
So as you have rightly pointed out, there are many grounds, but it is only on certain grounds.
Those grounds,
Which
Lordship,
has
I'll
been-
give the written thing.
Which has on
Whatever
which
they
the
have
arguments have been structured.
Yes, that is why the main grounds which they have argued are
Yes.
4 grounds.
Yes.
That constitution of the SLSC by 6 members is illegal. No research officer in the SLSC as members. The deputy secretary and the members of SLSC of the vigilance cell. So 4, 5 grounds they have highlighted in the writ petition, but they have expanded their case by arguing certain things which are not pleaded at all. So I am going to give counter to that also.
Okay.
Unpleaded grounds also they have urged. Like one of the grounds yesterday, that quorum and all, those were not pleaded. Lot of grounds were taken subsequently, and oral arguments are made without their lordship was pleased to put one question: where is the pleading? And the other side failed to show the pleadings. Yesterday, if I remember correctly.
Yes.
And also, the first report, second report issues. So straightway, I am taking your lordship to our affidavit. Because our affidavit covers everything, whether they have argued or not argued. If I'm allowed to place the affidavit in chronological order, or that will
Please.
clarify everything.
Yes.
Any questions thereof, I will be more than happy to give the response.
Which page it starts?
It starts at lordship.
Is it? Yes, I think it's 128. Is it
128.
Sushma Hazarika?
Yes, lordship. Susama Hazarika. So here the relevant paragraph will be paragraph 5. One notification is very important, Annexure 1
Of this affidavit.
of this affidavit. My learned senior friend from the other side referred to 2 judgments of the Supreme Court yesterday. Both the judgments were based on the rules and laws framed in that state, in Maharashtra. Here, what we are following, we do not have any statutory laws covering the scrutiny of caste certificate or social status certificate. We are basically relying on the Office Memorandum of 11th May 2011, page 148. This OM was issued on 11th May 2018.
Yes.
Straightway, it is following the principles and the guidelines given in the Madhuri Patil's case.
Correct.
So, in pursuance of the directive of Honorable Supreme Court in Kumari Madhuri Patil, the state government has decided to create a vigilance cell at the directorate level and issue modalities of its functioning. Accordingly, the following instructions are issued for further simplification of the procedure of dealing with the matter relating to fake caste certificate. Vigilance cell are to be constituted at each of the directorate. So initially we had 6 members. Why? Because our directorate was 2 parts. It was amalgamated in 2022. Therefore, the 2022 notification came out. Third notification which they have challenged. It has brought the number of members from 6 to 5. So it says that vigilance cells are to be constituted at each of the directorate. Directorate of Welfare of Plain Tribes and Backward Classes and Directorate of Welfare of Scheduled Castes consisting of Deputy Superintendent of Police CID Assam with such number of police inspectors as required to investigate into the social status claim of Scheduled Caste and Scheduled Tribes candidates. Superintendent of Police CID shall supervise the functioning of the vigilance cell. The vigilance cell shall function under the control of state level scrutiny committee. So this is the procedure regarding the vigilance committee. Now coming to the next. On receipt of the reference, the inspector who will be designated by the vigilance officer shall go to the police local place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate or the parent or guardian, as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parent, guardian, or the candidate. Lordship will kindly mark this or. In relation to their caste, etc., or such other person who have knowledge of the social status of the candidate and then submit a report to the concerned directorate together with all particulars as envisaged in the proforma, in particular of the schedule tribe relating to their peculiar anthropological and ethnological traits, deity, rituals, customs, mode of marriage, death ceremonies, method of burial of dead body, etc., by the caste or tribe or tribal communities concerned. The director concerned on receipt of the report from vigilance officer, if found that the claim of the social status is found to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue so-cause notice supplying a copy of the report of the vigilance officer to the candidate by registered post with acknowledgement due or to the head of the educational institution concerned in which the candidate is studying or employed. The notice should indicate the representation or reply, if any, would be made within 2 weeks from the date of receipt of the notice. In no case, only a receipt of request more than 30 days shall be granted from the date of receipt of the notice. In case the candidate seeks an opportunity, so he will have to seek an opportunity for hearing and request that an enquiry be made in that behalf. So he should request for enquiry also. The director on receipt of such representation reply shall convene the state level scrutiny committee and the secretariat chairman, who shall give reasonable opportunity to the candidate, parent, guardian to adduce all evidence in support of their claim. A public notice may be published in the village or locality, and if any person or association opposes such a claim, an opportunity to adduce evidence may be given to him plus it. After giving such opportunity either in person or to counsel, the committee may make such enquiry as it deems expedient and consider the claim as vis-a-vis the objection raised by the candidate or opponent and pass an appropriate order with brief reasons in support thereof. In case the report in favor of the candidate found to be genuine, no further action. Now coming to 9. In case the candidate, the certificate issued or social status claimed is found to be false, the parent, guardian, candidate should be prosecuted for making false claim. If the prosecution ends in a conviction and the accused is sentenced, it could be regarded as an offense under involving moral turpitude, disqualification of elective posts or offices under the state or the union or election to any local body, legislature or parliament. In fact, after 20th of January, he cannot remain as member of parliament because his certificate is already cancelled. As soon as the finding is recorded by the state level scrutiny committee holding that the certificate obtained was false, it should be simultaneously cancelled and confiscated, and the same shall be communicated to the educational institution concerned or the appointing authority by registered post. So the duty cast upon the state level scrutiny committee, after giving the opinion, simultaneously they have to cancel it, which they have done, and they have to confiscate. I do not know whether confiscation has taken place or not till now. And lastly, the order passed by the committee shall be final and conclusive only subject to the proceedings under Article 226. So this is the OM. And this OM is totally based on paragraph 13.
13 of
13.
Madhuri Patil.
Madhuri Patil. And they are happy with it. Nobody has challenged it till now. The committee which was constituted, Lordship will see page 150. Pursuant to the order of Supreme Court, the state level scrutiny committee, the governor is pleased to reconsider state level committee for scrutinization of fake certificate, etc. There are 6 members. Secretary of the Government of Assam, Director WPT and BC, Director Welfare Social, then Additional Secretary, Joint Secretary of Government of Assam, SP of Police, CID, Joint Director. They wanted that SP should not be there. For that, Lordship, I would like to place before this Honorable Court the judgment of the Supreme Court. Supreme Court initially said in 1994 that there should be only 3 members. And subsequently by another judgment in 1997, they increased it to 5 members. If Lordship is pleased to take Madhuri Patil,
Yes.
paragraph 13.4. 13.4 says, all the state government shall constitute a committee of 3 officers.
Yes. Yes.
Have Lordship got it?
Yes, yes.
All the state government shall consider a committee of 3 officers, namely additional or joint secretary or any officer hiring in rank of the director of the department concerned, the director, social welfare, tribal welfare, backward class, as the case may be, and 3, in case of scheduled caste, another officer who has intimate knowledge of the verification and issuance of the social status certificate. In case of scheduled tribe, the research officer. So this is the requirement. Now, by judgment dated 1997 5 SCC, page 437.
No, that was placed yesterday by Mr. Khurshid.
Yes, Lordship will kindly come to then.
No, you can, but you can just refer to what you want.
Paragraph 3
of the judgment.
of the judgment. As regard,
it was clarified.
it was clarified, it was enhanced. As regard prayer be read with direction number 4 of the order of this court, that means the Madhuri Patil's case.
Yes.
We do appreciate the inconvenience caused due to vast area of the state. Therefore, instead of 1 committee of 3 officers, there will be 3 scheduled caste scrutiny committees comprising of 5 members with quorum of 3 members, as suggested in para 4 of the direction to take a decision. So, number 1, it has been enhanced from 3 to 5 and also indicated what will be the quorum. Quorum will be 3. And regarding the 4th and 5th member, there is no special prescription who can be the 4th and 5th member. So the state, when the state in its wisdom thought the SP of CID will be an appropriate person because that department is entrusted with the job of finding out fake certificates and genuineness of certificates. So the state government in its wisdom decided that SP CID should be included there. So, and there is no prescription that the 5th and 6th members could belong to a particular category of officers.
Fourth and 5th member.
4th and 5th member. In Madhuri Patel in 13.4 says 3 officers in whatever category. They have specified three categories: research officer or the joint secretary as well as the director. These are the 3 categories. 4th and 5th, there is a vacuum. And that vacuum still exists. So we have to increase it to 5. And therefore, we inserted 2 persons here.
Yes.
1 additional. And subsequently, in 2000, Lordship will kindly come to page 152. This is a notification of amalgamation of the department of the governor's 2nd November 2022. Sorry, bifurcation.
Just give us a minute.
Lordship will kindly see page 150, that notification once more. Serial number 2 and 3.
Just a minute. This modification is not qua the state of Maharashtra. It is a general modification.
Yes, Lord.
Is there any indication? Because there is a reference that due to vast area of the state.
Yes.
State obviously meant the state of Maharashtra because the places Pune.
There 3 committees were allowed. Here we are having only 1 committee, but the number of persons has been increased. Maharashtra is a vast state. Therefore, the Honorable Supreme Court allowed that you should have 3 committees, and each committee should have 5 members. And that is in response because at the beginning, 13 he is indicated there. 13. As regard the prayer be read with direction,
Four,
Roman 4 of the order of this court. Order of this court means Madhuri Patil's case.
understood.
So in Assam, it cannot be equated in geographical territory wise that it is so big like Maharashtra. Therefore, we have not increased the number of committees.
Okay.
We only increase the number of members in a committee.
Though this direction was given for meaning the
Maharashtra.
state of Maharashtra, but it is in concerning the guidelines in
13D.
13.4.
13.4,
13.4 is all state governments.
all state government.
There was an enhancement of the numbers from 3 to 5
5.
with a further leverage that if you have a quorum of 3, you can still go on.
Absolutely.
So that the committees becomes effective.
Committee
Only
become-
because of in absence, because of the absence of one member,
Lord,
the committee should not be rendered
absolutely.
functionless. Okay,
Lord.
that we have understood. Okay.
And that same order has been passed in Madhuri Patil's case only. If Lordship is pleased to look at the parties,
No, that modification was not for.
modification.
Mm.
So page 140, there are 2 directors. Lordship will see
140.
150.
150.
Director, one is director WPT and BC, the next one is director welfare of social scheduled caste, SC. So
Okay.
later on, Lordship,
Okay. What about the 6th member?
here, whenever there is a issue relating to scheduled caste, the director scheduled caste, the concerned department, it is therefore that OM says the concerned director will sit. So ultimately, it is 5 members only.
Okay. Where is it?
If Lordship is pleased to the other page 148.
148. Yes.
Here, I have just read. Of the concerned department. Yes, 3. He says
Mm.
the director concerned on receipt of so-and-so found the claim of so-and-so, the director concerned should issue tokens. So if it is relating to lot of scheduled caste, one issue the scheduled type, the other part.
Mm. Mm.
There are 2 directorates.
Okay. And he will act as the chairperson.
Yes.
Oh, no, secretary. And no, he is act as what? Director on receipt of such representations shall convene a state level committee and the secretary as chairperson who shall be given. What is the meaning of this paragraph 4, third line
Paragraph.
at 148? In case a candidate, page 148.
In case the candidate seeks an opportunity of hearing and request that an inquiry to be made in that behalf, the director on receipt of such representation reply shall convene the state level scrutiny committee.
And
The secretary as chairperson, because if lordship is as chairperson is different person. Chairperson is the secretary of governments of Assam, WPT and BC department.
okay.
Serial number 1.
Okay. Okay.
So there is
Oh,
no dilution at all.
Okay. He mentioned the notification was meaning the secretary of the of the government who will act as the chairperson.
Yes, who will act as
Of
a
the
chairperson of the
committee,
state level
of
caste
the
scrutiny
committee.
committee.
Okay.
And the procedure is also given in this plot, page 150. The committee shall act upon receipt of any report of inquiry from vigilance cell pertaining to complaint received against the caste certificate held by a person, then complaints, etc. Number 4, on receipt of the report from the vigilance cell, the committee shall arrange 10 copies of the report to the petitioner against
Yes.
whom the inquiry was conducted along with a show cause notice, etc. Next page, if the concerned, serial number 5,
Hmm.
if the person concerned submits reply and also desires to be heard in person
Hmm.
and pray for engaging a lawyer, the committee shall issue notices to him directing to appear before the committee either in person or through counsel, all the necessary documents in original on a specified date for personal hearing. On the day of hearing, the committee shall examine all documentary evidence in support of the claim, record the hearing. After giving such opportunity, the committee shall make such inquiry as it deems expedient and consider the claim vis-a-vis the objections raised by the candidate or opponent or inquiry report and pass appropriate order with brief reasons in support thereof. So this is the procedure. Then 152, that notification of the state government regarding the reorganization of the department. Here, Lordship will see page 155.
152 is what?
The notification issued by the state regarding administrative reform in the state.
Well, how is it relevant?
How it is page 155. Only one department is interested. That Department of Tribal Affairs plain. Earlier there were 2 directorates. Now here only 1 directorate. Serial number 5, and Lordship will kindly come to page 156, serial number 7. Matters relating to state level scrutiny committee SLST for verification of scheduled tribe ST certificate.
155, 155. At the
155, the function of the Department of Tribal Affairs Plain Department. So this department was not there earlier. Yeah? Was not there. So this is a newly constituted department. If Lordship is pleased to come to page 152,
152.
152. In Lordship will serial number 1, in
Yes.
place of Social Welfare Department, Welfare of Plain Tribes and Backward Classes, there should be the new 3 departments: Department of Women and Child Development, Department of Social Justice and Empowerment, and Department of Tribal Affairs Plain. And serial number 4, the director, 2-4, the Director of Welfare of Plain Tribes and Backward shall be renamed as Director of Tribal Affairs. Then the matter relating to backward classes shall be formed as Director of Scheduled Caste and Scheduled Backward Class. So that way, Lordship will kindly come to page 155, functions of the Department of Tribal Affairs Plain.
Yes.
Next page 156, serial number 7. Matters relating to state level scrutiny committee for verification of scheduled caste ST certificate.
156.
156.
Serial number?
7.
Okay.
And page 155 also, there is another department part. Serial number page 153, third function of the Department of Social Justice and Empowerment shall be as follows.
Page 153.
3. Serial number 4.
Yes.
And Lordship will kindly come to page 155, serial number 18.
Yes.
Matters relating to state level scrutiny committee for verification of scheduled class ST and other backward classes OBC caste certificate.
Yes. That means for if the matter relates to a certificate
Yes.
wherein an allegation has been made, which is an SC
Lordship.
certificate, then this committee under the Department of Social Justice will take into.
Yes.
And if it is a tribal relating to a caste certificate of STP,
Lordship.
then the Department of Tribal Affairs.
Tribal Affairs.
Okay,
Therefore,
that
they
is
have
clear.
challenged this order. That's why I'm showing all this.
Hmm.
Page 159. 5th September 2022 also is the third prayer of challenge.
159. This is challenged.
Yes. This is also challenge. third prayer, if I'm not wrong.
Third prayer, 5/9/2022.
Yes. So here it is written, in view of creation of new department
Yes.
as Department of Tribal Affairs Plain, Assam, and in partial modification of the earlier notification dated 9/6/2021, the Governor of Assam is pleased to reconstitute the state level scrutiny committee for scrutinization of fake certificate for ST community with the following. So here there is one directorate, number 2, Directorate of Tribal Affairs Plain.
Hmm.
Now, if Lordship is pleased to come to my affidavit now. So I have covered paragraph 5 here.
That means this committee of by 5/9/2022
Yes,
is after the notification by the administrative reforms.
Lordship.
So what is the ground of challenge of this?
The inclusion of superintendent.
Okay.
One is inclusion and one is Lordship that there is not a qualified person from the tribal research community.
Mr. Khurshid was harping on the presence of the police person.
Lord.
That you will address, of course.
Lord.
That is there in this notification as well as in the earlier notification.
Yes, Lordship.
So this notification
Yes.
is only an extension of the
Yes.
challenge. It's not,
And if
not a
Lordship is,
specific.
yes, if Lordship is pleased to the notification at page 150, Joint Director AIRT and ST. So he's a research person, Lord, because they are one of the major ground was that research person or qualified person to look into this kind of affairs was not present. That joint director's whole credential we have stated in our affidavit. He is highly qualified and into this affair.
He is also there in the
First
subsequent.
committee, second committee, both committee.
Both. What is AIRT?
All of some tribal research. I'll just 1 second, Lord. I'll
Assam Institute of Research and Research for Tribal and Scheduled Caste. Assam Institute of Research.
I'm obliged to my pen.
Okay. AIRT. Assam.
So when we gave the credentials in the affidavit, and therefore there was no such argument on this point.
Of research.
For tribe
Page
and
number?
scheduled caste.
On tribes. NSC. Okay.
Now the complaint, Lordship will find complaint. The complaint was page 50 is the complaint.
50.
50. Yes, Lord. One Jonoklal Bosumatari, he filed this complaint on 11th of June 2019 to the Chairman State Level Scrutiny Committee. And the basic tenor is, Lordship,
11/6/2019.
2019,
Page 50.
page 50 of the registry.
11/6/2019. Complaint. By Mr. Das.
Yes, I'm taking his job now, Lordship. But he don't share anything with me. And tonight he is flying to Lordship Island. So he wants to complete the argument today itself. So my submission, Lordship, here is that
Complaint by R8.
R8.
Okay.
So here, Lordship, first paragraph I would like to place. With due regard, I have to lodge a strong complaint against the certificate issued to Novakumar Poronia by all Assam Tribal Sangha, Tamulpur, and countersigned by SDO, Tamulpur, on 17/10/2011. The certificate issued to him saying that he belonged to Boro Kochari, which is a recognized STP under Constitutional Order 1950 as amended. Under 342(1) of the Constitution, the President of the Constitution of the Governor, with the consultation with the Governor of state by public notification specified the tribes and tribal communities. Under Article 342(2) of the Constitution, the Parliament may by law include or exclude from the list as specified in notification issued under Clause 1 any tribe or tribal. So according to him, he is referred to the presidential order, and here it is indicating that page 151 in Assam, basically Boro and Boro Kacharis are included in that part, apart from others. I'll take your lordship to that notification. So this is the basic ground on which the complaint was lodged. So his complaint was received, then the department had nominated, lordship will kindly come to page 55.
Yes.
Page 55. In pursuance of the government poem dated 11/5/2018, a vigilance cell is hereby constituted in the Director, WPT and PC department to deal with matters relating to fake caste certificate. This is a general one, Lord. It has nothing to do with this particular case. So
It's a
Director, WPT and
vigilance cell.
vigilance cell. Then Deputy Director, then Deputy Superintendent of Police. According to Madhuri Patil's lordship, Senior Deputy Superintendent of Police should be there. We do not have that post in Assam, so we included the DSP, CID, and Police Inspectors 2 numbers. So this is the committee. And thereafter on 26/6/2019, this later reference lordship will find subsequently in the report. The Special Superintendent of Police CID entrusted Jodu Malakar.
Page
156.
Next page.
Yes, Lord. In inviting reference, the following DSPs and inspectors are nominated for vigilance cell as members from CID to deal with matters relating to fake caste certificate. So 3 persons were appointed: DSP Satpal Function, Inspector Jodu Malakar, and Inspector Dipojyoti Datta. And thereafter, the committee met. Page 58.
Yes.
The receipt of the complaint, and thereafter, inquiry was entrusted to Jodu Malakar.
Is it 59?
Page 15. Yes, 59. From Vibhas Modi, Director, to Jodu Malakar, verification of caste certificate. Three persons were indicated here. Serial number 2 is Janaklal Bosumatari's complaint. And the complaint is against Sri Nobakumar Koronia. Honorable Member, Kokrajhar HPC.
4719.
So this was dated 38th July. The lordship will find that date at page 60. 37/2019.
Yes, got it.
After the inquiry was continuing, lordship, he submitted one report on 25/10/2019. He submitted on 23/10, and it was formally submitted with a covering letter dated 25/10/2019, page 62. So the SP of CID submitted the report given by Jodu Malakar to the Director of the department. Here, one very interesting thing, the other side is trying to rely upon this. And I'll be more than happy if they give more stress on this slot. Because the finding here is very clear. 23/10/2019. CID
63.
Page 63, furnishing of the inquiry report. Here, lordship will find the narration I am not reading. Serial number 1 is in respect of some other person. Serial number 2. May I read it, Lord?
Please.
For verification of caste certificate of Nobakumar Koronia, MP Kokrajhar, son of Lakshmikanta Koronia of Digholipar, Tamulpur, Baska. I visited the given address, examined the persons noted and other prominent persons in that locality, and found that the person belongs to Koronia Kosari community. The whole quarrel is whether he belongs to Horonia Kochari or he belongs to Boru Kochari. So he found that the said person belongs to Horonia Kochari community, which is under the purview of STP category. Why? Because at that point of time, there was a government notification in force. That notification I'd like to place before this honorable court, which has been referred in this report also. In this regard, I collected the copy of the letter issued by the government of Assam, Department of Welfare of Plain Tribes and Backward Classes, Dispur, Guwahati, referred on dated 15 June 2018, addressed to all Deputy Commissioners of Districts of Assam and all SDO civils of Assam, directing to issue STP certificate to Horonia Kochari community as Kochari tribes of Assam. For ready reference, I am enclosing the photocopy of the caste certificate along with the government letter as ready reference, which is annexed as Annexure B. So, by this notification, if Lordship is pleased to have a look, because this was immediately put to challenge and government had no other options but to withdraw it also. This notification says, with reference, I am direct to inform you that in consequence of the Honorable High Court order dated so and so, and the matter of issuance of scheduled caste plain tribe plain certificate to Horonia Kochari community has been under consideration of the government. It has now been decided in pursuance of the consensus arrived in the meeting held with representatives of all Assam Tribal Sangha and representatives of Horonia Kochari community on 9th February 2018, and also the report received from the Assam Institute of Research and Tribe Scheduled Caste on the caste status of Horonia Kocharis, which are that all persons belonging to Horonia Kochari community will be issued scheduled caste plain certificates under the subtribe Kochari with immediate effect. All such caste certificates will be issued after proper identification and verification as per the existing procedure. So this was issued on 5th of June 2018, and thereafter, when this was issued, immediately a PIL sprung up, Lordship. PIL 30/2019. Lordship, the order. The order is dated 1/3/2023. PIL is numbered
Was this
30/.
against, was this against 15/6? Was this
15/6.
PIL against 15/6/18?
Yes, Lordship.
That notification by which?
Yes, that notification, Lordship, I am
So
coming.
no, the Horonia Kochari was given the
Yes,
status.
Yes.
Okay.
That PIL was registered as PIL 30/2019, and the matter was taken up for final consideration of 1st March 2023.
Yes.
Lordship will kindly come to the second page.
Yes.
The first page, this PIL is instituted by Kalpari Educated Unemployed Youth Society, and another assailing the notification of 22/6/2009. That is one part. Then Lordship will kindly come to the same paragraph, last 5 lines. The petitioner also assailed the communication dated 5/6/2018. That is the second round, second prayer.
Where?
Second challenge. The 5 lines from below of the top paragraph.
A paragraph? Which paragraph?
Paragraph 3.
Okay, 5 lines from below. The petitioner.
The petitioner
Yes.
also assailed
5/6.
5/6 from the commissioner and secretary government in WPTF made to all deputy commissioners, sub-divisional officers
Read it.
as regarding issuing STP as Horonia Kochari community as Kochari tribe in Assam. Paragraph 9, Lordship now. As regard the other notification dated 5/6/2018 by which the commissioner and secretary government of Assam in WPT and PC department had provided that all persons belonging to Horonia Kochari community will be issued STP certificates under subtribe Kochari. The secretary to the government of Assam in the tribal affairs department has made a statement before the court that the said notification in the meantime had also been withdrawn and it will not have its effect under the law any further. So, if Lordship is pleased to look at the 2 papers I have submitted now,
Yes.
I would like to give it to the other side also. Yeah. This was withdrawn on 20th February 2023. With reference to above, I am directed to state that the communication made dated so and so 5/6/2018 stands withdrawn. There are two reasons why it was withdrawn, Lordship. Apparently, there is the Honorable High Court's order. That order is a part of our reply. No, it is a part of the writ petition, page 100 and 237.
Yes, 200 and
237. At that point of time, there was a challenge to the certificate. Jonaklal Kusma, same complainant versus State of Assam, including the present writ petitioner Nobo Horonia at serial number 7 in the respondent side. In this order dated 28/5/2014, if Lordship is pleased to come to the penultimate paragraph, my Lord Justice Agarwala's order, I have also perused the list of scheduled types incorporated in Central Order number 2, and prima facie it appears to me that Horonia is not enlisted tribe who the tribe certificate has issued to 7. Accordingly, in the interim, it is ordered that the respondent 5 and 6 shall confine themselves to issue type certificate only to persons falling in the categories listed in the Central Order 22 as amended till date. So there is a direction of this Honorable Court not to issue to any other persons other than the persons mentioned in that Presidential Order, Central Order 22. And the writ petition was withdrawn after the PIL was disposed of. This petition was withdrawn on 3/2/2023. So what I am trying to emphasize is that Lordship is pleased to look at the presidential order, because we are now dealing with this. That is at page 202.
this writ petition was withdrawn, 2580 withdrawn.
It was withdrawn in 2023 after the PIL was closed.
Well, this was also before a DB.
DB, it was called,
Okay.
it was before the single bench, that finally when this matter was taken up,
Okay.
the PIL Lordship, somebody I think have mentioned, or maybe the Honorable Court wanted, that both the issues relating to the same
Right.
subject matter, they were tagged.
Yes.
So the presidential order, Lordship will find at page 202. In exercise of the power conferred by clause 1 of Article 242,
You are reading the 1950 order.
1950 order.
Yes. 202.
In fact, this is my base, the number 1 argument for. In exercise of the power conferred by clause 1 of Article 342 of the Constitution of India, the President, after consultation with the Governor and Raj Pramukh of the states concerned, is pleased to make the following order. So order is that list is prepared. It starts from the schedule, page 203, Andhra Pradesh, Assam. People kindly see Assam.
At,
page
Okay.
203.
yes. Yes, please.
It starts Assam, then page, Lordship will kindly come to page 204. In the state of Assam, including the Bodoland territorial areas district and excluding the autonomous districts of Karbi Anglong and North Kachar. Number 1, Bormon Sin Kachar, Boru Kachari, Boru and Boru Kachari. So in BTC area, the state of Assam, including BTAD area, Bodu and Bodu Kacharis are SCP.
Yes.
So we don't find Poronias here. And thereafter,
And Mr. AG, we can perhaps cut it short because the arguments which you have
no,
understood.
Lordship, these are very vital facts because today they may not argue. In the next forum, all these things are part of the record.
No, just listen to the quote. Yesterday, thrust of the argument was that
I'll
That,
finish in 5 minutes.
that
I'll give a written
surname is not the determining factor.
Absolutely.
So his client, the
Yes,
petitioner
Lordship.
writes.
I'm not on Saranya. Now what happened? The
Yes.
state of Assam wanted that Saranya Kosari should be made tribal.
No, that was excluded. That notification has been excluded. Now it's not there.
No,
So,
there is something else. In 2011, which I'm going to place it now. In 2000, the state government and the central government wanted that Saranya Kosari should be granted the status of scheduled tribe. And that bill is still pending. That is what I'm going to show now. It is very relevant.
but what has been argued is that though he
Their
writes,
argument is one thing, Lord.
though he writes the surname
They
as
are
Saranya,
arguing certain things which are not there in the petition also. But I have to go. I have to give the complete picture. Then I will, whatever they have argued, I can finish it 5 minutes, Lord. But the facts, Lord, because I'll have to place some judgment also. The facts are very important. Later on, they will say, Lordship, we do not know which way the matter will go. These are very vital, important things. It has a ramification in the society. 217.
217.
217. In fact, I am rusting. I am actually trying to cut short as much as possible, Lordship. 217. The Constitution Scheduled Tribes Order, Second Amendment Bill 2011.
Just a minute, please. Yes.
Yesterday, I mentioned that a lot of things were not placed. But these are part of the hard record, Lordship.
What is there in this second
Yes,
amendment?
Lordship, we can see the Constitution Scheduled Class Order Amendment Bill. It has
2004.
not never become act now. Lordship will kindly come to page 233. Regarding Assam, serial number 8.
233.
233. Poronia Kosari. Refer to the state government for further justification on the comment by RTI on 5/5/2006. And in the bill also it was included, nothing has progressed thereafter. Why it is relevant, Lordship, that Soronia Kosari, because the report given by Malakar in October 2019 says he is a Soronia Kosari, and they are harping that that is a correct report. So Soronia Kosari is not tribal as on date. The bill was moved in 2011. It was never passed in the parliament. So that is why it has relevance. Page 63, Lordship will kindly come now.
Page
63 of the repetition.
Yes.
Page 63, last paragraph. For verification of caste certificate of Nobokumar Poronia so I visited the address and found that the said persons belongs to Poronia Kosari community. This is not challenge. This they are emphasizing. that it is to their favor. And her sister also says, we belong to Foronia Kostari community. So if he belongs to Foronia community, Lord, the Foronia Kostari community, then he is covered by the Bill of 2011, which is not an act. Their own admission, undisputed facts. However, Jodu Malakar, when he submitted this report on 23/10/2019, that 2018 6 June notification was in force, which was withdrawn on in the year 2023. Therefore, his opinion at the last part of this, in course of inquiry, page 64, Lordship, it is found that the complainant lost by the civilians so in the Fatima Khatun, Jonaklal Bostumate and so is not genuine. The incumbents noted below are OBC, STP and so. So according to him, Novo Kumar Forolia belongs to STP community. What was his basis? The notification. In paragraph 2, very categorically says the notification of 5th June 2018.
Okay.
So the committee thought that the report is not complete and the same officer further inquired. Lordship will kindly come to page 74. By the same officer.
Just a minute, please.
Okay.
Where page?
Page 74.
Yes.
Here, Lordship would kindly see reference the letter dated 37/2019.
This what is this page 74?
Page 74 is the report. Continuation of the report.
Okay. 74. What is the date?
Date is Lordship 4/2/2020. 4/2/2020, page 81. Lordship will find that date. And Lordship, it starts at page 74. And here there is a reference of 37/2019 and 37/2019. Lordship will find that at page 59, by which the director WPT and BC department.
Page 59.
Page 59.
Yes.
Entrusted Jodu Malakar, inspector and vigilance officer, to verify the caste certificate of Novo Kumar Foronia along with 2 other persons.
Yes.
So this report is a detailed report in inviting a reference to the subject cited above and then continuation of the previous report. This is very important. Here it is not an issue of first report, second report, or composite report, I would like to use the term. So, and in continuation report, I have the honor to submit a report on the complaint submitted by Jonaklal Bostumatari of so against Novo Kumar Foronia of so village, which was endorsed to me for inquiry. As directed, the inquiry was conducted taking into consideration below mentioned points along with those mentioned in the OM dated 11th May 2018, Annexure A of the WPT and BC department, ancestor caste status, legacy data verification, land documents, admission reports in educational institutions. Now, he completed the full inquiry and submitted this report on these parameters, which is necessary in terms of paragraph 13.5 of the Madhuri Patil's judgment, as well as the office memorandum of 11th May 2018. What did he do, Sir Lordship? Steps taken during inquiry. A very long report, Lordship, but I do not want to take much time. But he made the complainant he met all the concerned officials of the tribal Sangha, etc. He visited the serial number 4. I visited the native place of Nobokumar Koronia, etc. Then he met Ojit Boru. He visited Tamulpur Government MV School, serial number 6, because these are required as per the direction of the Madhuri Patil. 7. During the course of inquiry, the following witnesses whose names are given below were examined and their statements were recorded. Gaubora Roman Rabha, Suresh Rabha, Pabdo Rabha. Then statements of the below mentioned witnesses. I visited DC office Baska. I visited Revenue Circle office Tamulpur. I also examined the Lat Mandal, page 77, top line. I also visited Tamulpur Higher Secondary School, where Nobokumar Koronia was a student from class 8 to higher secondary and collected HS per etc. And findings, Lordship. From the above, copy of the above official letter forwarded to the Secretary Government of Assembly, it has been found that the concerned officers still receive a direction from the authority. The process of concerned Koronia as is kept in abeyance. That notification. At the very beginning, he said that it has been stayed. Then, affidavit of Vinita Pegu, Deputy Secretary Government of Assam, to the Honorable High Court on 26/5/2015 has revealed in point number 9 of the affidavit. The deponent clarified by saying that the deponent Victor Soronia Kosari has not been enlisted in the SC list of Assam as per the scheduled caste and scheduled tribe order as amended from time to time. Then 1977's notification. Then serial number, that certificate which is in question, Lordship. Here it has been mentioned that Koronia Kosari, Boru Kosari is the tribe of Nobokumar Koronia, serial number 5. In his statement, General Secretary of the All Assam Tribal Sangha Tamulpur, etc., stated that there is record of STP survey which was issued to Nobokumar Koronia, signed by the then Vice President late Kailas Prabha. Then Deepika Das stated that it has been found that 26, since her husband was working in military expert, she has 6 children, 3 sons, 3 daughters, and all of them have caste certificate. She further stated that she has no caste certificate of her own, as there was no requirement of caste certificate at that time. She also said her husband had no siblings and he wrote Das as his surname. Deepika Das is mother. Then sister, Dipanita Koronia, sister of Nobokumar Koronia, stated that she is working in a beauty parlor and had stopped studying after passing PU from Tamulpur HS. She further stated she has STP certificate and she and her family belongs to Koronia community. Sister also said, and her family. Although we are not emphasizing on affinity test, but these are the affinities. Sister says Koronia community. The police officer first time says they belong to Koronia community. And her father used to write Das as the title. Sri Ojit Boru, President of Apsu Tamulpur, stated that Nobokumar Koronia residence is located at Digolipar and he originally belongs to Coast community. In fact, that is the actual caste. He became Koronia after taking Koron. So one cannot change lordship caste by taking Koron. Even by marriage, one cannot change. His father lived Lokhikanto Das and mother wrote Das as their title. He further stated Koronias do not belong to STP. Scrutiny of admission register of Tamulpur MV School for the year 1982 also revealed that the name of Nobokumar Koronia was written as Nobokumar Deka of Lokhikanto village so entered as serial number 59. In the certificate issued by Commanding Officer of Assam Regimental Center Shillong, titled Certificate of Discharge and Transfer to the Reserve and Recommendation for Civil Employment dated 15th November 1980, the name of Nobokumar Koronia's father was written as Nayak Lokhikanto Das, son of Sela Das, and his class was written as Assamese and subclass as Das. So, but whether Assamese or Das is not important. He has not stated that scheduled class tribe. Plain, scheduled class plain. STP. From above fact, it can be found that Nobokumar Koronia and his family were using titles Das Deka, which do not fall under the category of Boru Kosari. Roman Rabha stated that he is a government Gaupura. He is permanent Gaupura of village so and so, and he was also taking charge of Digholipar, serial number 4th line, Lordship, Digholipar last name, that is the village. He stated that Nobo Komborania was born in Digholipar village. His father's name was late Lokhikanto Das alias Korukuch. His father expired around 25-26 years back and was working in Assam Regiment. His father expired during accident while working in Assam Regiment. The name of Nobokumar Koronia's grandfather was late Selaram Das. They are originally from Digholipar, as both the grandfather and father were born there. Nobo Koronia's family actually belonged to Caste community, who became Koronia after taking religious Koron. The mother of Nobo Koronia is Deepika Bala Das, whose marriage was conducted based on mainstream rights, not in the tribal way, Lord. This is another requirement under paragraph 13.5 of Madhuri Patil. Tradition, etc., and not according to the traditional rites, rituals of Boros and Raphas. The NRC legacy, that is of 1951. The NRC legacy data shows that the title of Nobokumar Koronia's father was Korukuch, which do not fall under Boru Kochari. In the land chita register, the name of Nobokumar Koronia's father was written as Lokhi Korukuch, Estella, son of Stella Korukuch, address Digholipar. In the land Jamabandi record, name of Sri Nobokumar Koronia's mother was written as Srimati Deepika Das, was struck off, and Korukuch was written just above the name. Another title, Koru Das, has also been given in bracket below the name Deepika Das. The name of Nobokumar Koronia's father was written as late Lokhi Kanto, followed by which may be assumed as Koru Das. There is another entry in the name of Nobokumar Koronia's mother as Deepika Das Koronia, wife of late Lokhi. According to HS certificate, father's name of Nobokumar Koronia was recorded as Lokhi Kanto Koronia. From the above given points, which are collected during the course of enquiry, it can be seen that the process of countersigning Koronia people shown as Rabha or Boru Kochari has been kept in abeyance by the concerned SDO Civil and Sri Binita Pegu, Deputy Secretary Government of Assam WPT and BC Department, in her affidavit submitted to the Honorable High Court on 26/5/2015, had stated that Koronia Kochari had not been enlisted in the SC list of Assam as per the Scheduled Caste and Scheduled Tribe order as amended from time to time. Moreover, O.R. Srinivasan, Under Secretary Government of India, a letter dated 22nd March 1977, had cautioned against issuing certificates without proper verification. Observing that Koronia is not enlisted tribe in the list of scheduled tribes incorporated in Central Order 22, though tribe certificate has been issued to Nobokumar Koronia, the Honorable High Court in WPC Soens of 2014 by order dated 28/5/2014 ordered all Assam tribal Sangha to issue tribe certificate only to those persons falling in the categories listed in Central Order 22. Further, Deepika Das stated that her husband had no siblings and wrote Das as her title surname. Sri Dipanina Koronia, sister of Nobokumar Koronia, also stated that her father used to write Das as his title. This was further confirmed by Udit Boru, president of Aksu Tamilpur, who stated that Nobokumar Koronia's descendant is located in Digholipar village and originally belonged to Kush community. He became Koronia after taking Koron. His father, late Lokhikanto Das, and his mother also wrote Das as their title. Government Gaupura's statement also same thing. Then, taking into consideration the practice of Boru Kochari is to use surnames peculiar to the community and related to nature, such as Bosumatari, Art Folk, Narjari, Jute Folk, Doimari, Water Folk, Islari, God Folk, etc. The claim of STP certificate by an individual whose title surname is Das as Boru Kochari leads to suspicion. Moreover, the statement of Gaupura Roman Rabha that the marriage ceremony of Nobokumar Koronia's parents were not conducted according to the traditional rites, rituals of the Boros and Rabhas further gives credential to the contention that Nobokumar Koronia and his ancestors are not tribal and that they do not belong to Boru Kochari. Scrutiny of admission register of Tamulpur MP School for the year 1982 has revealed the name of
almost repetitions of
repetition, Lordship. So finally, surname things are also stated. So this is the report, and report was received on 4th of February, and thereafter on 11th of March, page 82, the so cause notice was issued. So whether it is first report, second report, everything will culminate into this report, and this report was given to him. After the first report, further inquiry continued. Lord. That is an internal affair. That was not a report finally given. And that report, Lordship, it was very basic. That to which community he falls and what is the relevance of the particular communication, which entitled all the deputy commissioners and the sub SDOs to issue certificates to Koronia Kosari people as STP, which was withdrawn and which was totally in violation of the constitutional order. One cannot do. The state government does not have that power. It is the parliament, the president of India, who will have to consult with the governor or the Raj Pramukh. It cannot be at the whims and fancies of the state government officials or the executive here. The so-cause notice was issued on 11/3/2020. So basically, all these are repetition. And Lordship will kindly come to page 84. Here we have said, whereas prima facie it is found that the fifth paragraph from top below.
Yes.
It is found that the report of the vigilance officer that STP survey issued in your favor is doubtful from different angles as enunciated in the inquiry report, copy and close. Whereas in view of the findings of the vigilance, your STP certificate is liable to be immediate cancellation and confiscation. And he was also given, you are therefore requested issued notice to submit your explanation as to why government in the W should not cancel your certificate. Your replies to reach on certain stuff. Should you require more time for submission of explanation or desire for opportunity of hearing, your petition for the same has to reach the undersigned within 2 weeks. Enclosed copy of vigilance officer's report. At one point of time, they argued that they have not received any copy. But from the day one, the report was given. Thereafter, they requested for additional time because the COVID was in force at that point of time, and they want some more time. Lordship will kindly come to the page 85. They found some of the documents were not there or maybe illegible. Third paragraph. Whereas in view of the government imposed lockdown due to COVID, your request for extension of time has been accepted. Whereas it is pointed out a copy of the inquiry report was enclosed with the so-cause notice issued to earlier dated so and so refer to. However, your request for copies of statements and documents have been accepted and thereby copies of the documents are attached with this letter. Another date was given. Last line. Further, your request for personal hearing shall be considered only after receipt of the detailed explanation. Then copies were furnished. Then few copies were not legible. It was furnished further. And then the reply came on 31st of August. Page 87. So here, Lordship will kindly see the letter dated, the so-cause notice dated 11/3/2020, your reference. Then my reference request letter dated 8/4/2020 and 18/6/2020. So whatever request he has made, Lordship, everything was acceded to. First 2-3 paragraphs and the first page, Lordship, he finally submitted page 88, third line from below in the penultimate paragraph.
Yes.
Therefore, after receipt of the documents, I am submitting my reply to the so-cause notice within stipulated time after receipt of the documents. And I would also prefer for personal hearing after submission of reply. So he requested this personal hearing. Then objections are there. Here, one important thing regarding constitution of the committee, he at the very beginning said it has been constituted as per the. I'll place that. Yes.
Which
Paragraph
page?
5, page 90.
90.
90. The state level scrutiny committee has been constituted by the government on the basis of the judgment of Honorable Supreme Court passed in Madhuri Patil, so and so. By the aforesaid judgment, guidelines had been formulated. So regarding the other guidelines is different, but he has no objection regarding the constitution of the committee. He himself admits
that it has been done as per the direction of the Honorable Supreme Court in Madhuri Patil's case. His own admission. If Lordship reads the complete paragraph, there is not a single whisper he has any objection regarding composition of the committee. He submitted before this committee. If he was aggrieved, Lordship, he should have challenged at that relevant point of time immediately. And he is not a layman, Lordship. He is a member of the parliament for 2 consecutive terms. So the committee was constituted in 2018 or 2019, whichever date, Lordship.
2009, that was, that we have to tell, 2009 first one.
So when the show cause notice was issued, the committee, everything was known to him. So he submitted and he categorically said the state level committee has been constituted by the government on the basis of the judgment of Supreme Court. His own submission, own admission. He has considered paragraph owing to the reasons that my society already reached its finality, etc., regarding relating to various other cases.
Yes.
He also says, paragraph 2, page 91, Roman 2. With regard to the statements of allegations made in highlighted in point 2 of the show cause notice, I state that the order dated 28/5/2014 passed in WPC 258014 by the Honorable High Court observing that Poronia is not an enlisted scheduled tribe is the correct position of law. The officer says Poronia committee, his sister says Poronia committee. Now he also says that Poronia committee is not enlisted in the list. He stated that the complaint was lost due to political rivalry, etc. But very importantly, Lordship, not a single document, not a single evidence has been mentioned or indicated here.
Now you read the page 91, the paragraph 2, because he's tried to give an explanation that you are harping upon Soronia, but the certificate describes me as a Boro Kachari.
That is what the Boro, if he is Boro Kachari, he will have to give us some evidence that he belongs to Boro Kachari. Just saying I belong to Boro Kachari. Tomorrow I can also say I belong to Boro Kachari.
That means you are going back to the findings in the continued inquiry, where
Absolutely, Lord.
an inquiry was made and it was tried to be found out whether his claim to be an STP is justified or is correct, not
Yes.
justified, is correct. And you have found materials which, as
Sufficient
per
materials.
you, that there is no indication that at any point of time he is a tribal plains.
He belongs to Boro Kachari or Boro, because 2 categories are indicated in the presidential order, Boro or Boro Kachari. None of the documents indicates that he belongs to that category.
Except the certificate.
Except the certificate without any verification. I do not know on what basis they have issued it. The High Court also, Honorable High Court also said that don't issue like that. In 2014 itself, don't issue certificates by all Assam tribal Sangha to people who do not belong into that category of persons enlisted in the presidential order.
Is the jurisdiction of the issuing authority ever interfered or anything said by this court?
No.
That is not that has not come up in any.
That has not been an issue in any case.
Whether this particular organization is competent to issue a certificate in any genuine case.
I think they are competent, but they must have proper basis.
Okay. And the basis is a different
Yes,
aspect.
yes.
On the competency part, jurisdiction part.
That has not been an issue in any manner.
Okay.
Introductory authority.
So here all our documents, all our evidence lead to one conclusion, that he does not belong to Boro Kachari. One, the other one is that he belongs to Soronia Kachari.
from his own antecedent, family members' statements, and all the relevant documents. Now, in his reply, except his own saying that I belong to Boro Kochari, that is his own conviction, I fully appreciate that. But that must have some support, documentary evidence, or evidence of some person who will say he belongs to Boro Kochari. Lot of arguments has been made that evidence could not be adduced. Where is the prayer? They have given all these things, but not a single annexer, nothing. And page 101, this is my reply to the so-called notice dated 11/3/2020. And I may be permitted to submit additional reply if so required to clarify my stand. I would also prefer personal hearing after submission of the reply. He wants personal hearing. That means he himself is the person who should be heard. But there is no request for any witness to be called to the inquiry. So there should be a request. I'll not use the word demand. There should be a request at least. If he wants to examine anybody, if he wants to cross-examine anybody, and as he has not indicated anything in his reply, Lordship, the authorities or the committee has no business to give him advice because he is well advised. He himself is the MP and he is accompanied by group of advocates. That Lordship will find in his additional reply. He wanted to file additional reply. We allowed because his first reply was submitted on 31st of August 2020. And the second reply he submitted on 21st of December 2020.
First reply is of
31/8/2020.
Right.
And the second report,
Second reply. Additional reply.
yes. So once the reply was there, Lordship.
When was additional reply?
I'll take your Lordship little bit later.
Okay.
21/12/2020. I'll place that report little bit.
2020.
But immediately after first report,
Okay.
the Director of Vigilance Cell had a meeting, page 102. The committee, this Vigilance Cell said, second paragraph, after thorough discussion among the members present, the following resolutions were adopted. The case relating to Nobokumar Khoronia would be referred to the state level scrutiny committee for adjudication and personal hearing as requested by the defendant, Sri Nobokumar Khoronia. A letter shall be sent to the chairman state level scrutiny committee enclosing copies of all documents relating to the case for convening a meeting of the SLK for adjudicating the case. So the vigilance cell decided that it should be sent to the state level committee. And state level committee, before the state level committee, Nobokumar Khoronia, the honorable member, submitted an additional reply. Lordship will kindly come to page 108 for the date.
No, but this we have not understood why. Because the so-called notice
Was given by the director.
was given by the director. And with enclosing the report on 11/3/2020 to the petitioner.
Yes. And the report.
And
reply.
why is this? Then he gave a reply.
Yes.
After the reply, matter has been referred to the SLST.
SLST.
Okay.
And the reply was given to the first reply, page 87. It was given to the director. Because
Okay.
director issued the so-called notice.
Right.
13/6. Now 13/6 comes of Madhuri Patil.
Yes.
Page 108. Lordship for the date.
108.
108. Because in his reply, he stated, I may be allowed to give additional reply also if necessary. So now he has written to the chairman state level scrutiny committee because now the ball has changed. Is filled.
108.
108, the date down below,
Yes.
21/12/2020, because it was referred to the committee on, I just said 14/9.
14/9.
14/9. So
Okay. In fact, he has addressed to the committee itself.
this time it is committee. The
Committee.
reply was with the director.
The initial reply was the director. The second reply is
Yes,
with the committee.
I am not finding any fault here. What I am trying to emphasize, because he wanted additional reply,
Yes, yes.
we gave him. He want personal hearing, we gave
Yes,
him.
yes,
And
yes.
Lordship will kindly come to page 105. The Director of Welfare of Plain Tribes and Backward Classes.
Yes.
The Director of Welfare and Plain Tribes, sorry, that the Director of Welfare of Plain Tribes and Backward
You're
Classes,
writing
Assam,
105.
105
Okay.
from top.
Yes, yes.
Circulated a letter dated 7/11/2020, calling for the state level scrutiny committee meeting to be held on 11/11/2020 for caste verification of me and another. A copy of the aforesaid letter was also communicated to me. Accordingly, I, along with my learned advocates, appeared before the state level committee on 11/11/2020 at 11 p.m. in the third floor, Janta Bhavan. So what I am trying to say here, Lordship,
Yes.
that he was heard, he was accompanied by advocate, he wanted personal hearing, and at no point of time he wanted to adduce any evidence.
Not referred in that purpose.
But Mr. Saikia, this second reply he has given after appearing before the SLSC on 11
Yes.
11/2020.
Yes.
Because the second reply is dated 21/12
Absolutely, Lord. So he felt that I should give something more
to the committee.
to the committee. So he gave something more. If he wanted to have that, I want X, Y, Z to be personally examined, or I want to examine E, F, Y for cross-examination, he should have told. Where is that demand? The demand, if I let me place paragraph 6 of Madhuri Patil, Lord. Let us stop here for a moment and let us go to what the Honorable Supreme Court said.
Yes.
So paragraph 13(4) says about the Constitution. 5, how the vigilance cell should operate, and 6, how the inquiry should be done. May I read 5 and 6, Lord?
Yes, please.
Each directorate should constitute a vigilance cell consisting of senior superintendent of police. In Assam, it is DSP, in overall charge, and such number of police inspectors to investigate into the social status claims. The inspector would go to the local place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. So I have indicated from the report which are the places he visited, his village, etc. The vigilance officer should personally verify and collect all the facts of the social status claimed by the candidate or the parents or guardians, as the case may be. He should examine the school record, birth registration, if any. He should also examine the parent, guardian, or the candidate in relation to their caste. So sisters, parents, whoever was available was examined.
Yes.
And everywhere it is or, option is there. Or such other person who have knowledge of the social status of the candidate, and then submit a report to the director together with all particulars as envisaged in the proforma, in particular of the scheduled tribe, relating to their peculiar anthropological and ethnological traits, deities, rituals, customs, mode of marriage, death ceremonies, method of burial of dead bodies, etc., by the caste or tribe or tribal communities concerned. The director concerned, now 6, on receipt of the report from the vigilance officer, if found that the claim of social status to be not genuine or doubtful or spurious or falsely or wrongly claimed, the director concerned should issue so-cause notice supplying a copy of the report of the vigilance officer to the candidate for a registered post with acknowledgement due, or to the head of the educational institution concerned in which the candidate is studying or employed. The notice should indicate the representation or reply, if any, would be made within 2 weeks from the date of the receipt of the notice, and in no case on request more than 30 days from the date of receipt of the notice. So the time is also fixed, so not
Yes.
beyond 30 days. Here, it was submitted in August. Notice was of 11. COVID was there for 2 weeks, for 3 weeks. He was given extension. And we received reply in December also, the additional reply. In case, now here the crux comes. In case the candidate seeks an opportunity, he will have to seek an opportunity of hearing and claims an inquiry. So hearing, he asked us, but he did not want inquiry again. So the onus lies with him that I want inquiry, I want personal hearing. In all these papers which I have placed, Lordship, he said, I want personal hearing, I want to explain, etc. He never said that you reopen the inquiry. All these people again. There should be examination on chief, there should be cross-examination. So there should be a demand. The Honorable Supreme Court laid it very clearly, without any ambiguity, that in case the candidate seeks an opportunity, so he should seek it. It cannot be offered to him on a platter. And claims an inquiry to be made in that behalf, the director on receipt of such representations shall convene the committee and the joint secretary, etc., who shall give reasonable opportunity to candidate, parents, etc., to adduce all evidence. So he will have to seek, then that opportunity will be given to him. Here he does not want to bring any. Now wisdom has grown. By meeting my friend maybe. But at that point of time, he did not opt it that. In 2020, he did not opt it that I want to examine, I want to re-examine, I want to cross-examine. All these opportunities he waived. And it is not the duty of the committee or the director or any persons of the government to advise him. We should be fair to the complainant as well as to the person against whom the complaint is made. So the procedures laid down here, where we have faulted from. So in case the candidate seeks an opportunity of hearing and claims an inquiry to be made in that behalf, the director on receipt of such representation reply shall convene the committee and the joint secretary, agent secretary as chairman, who shall give reasonable opportunity to the candidate, parents, guardians to adduce all evidence in support of their claim, a public notice, etc., etc., etc. So this is what I am trying to emphasize, Lord, that the request should come from him. He should must have an indication. He should have a request. He should have a demand. And when he requested for additional reply, additional hearing, all these opportunities were given, and he was accompanied by advocates. So my humble submission is that, Lordship, when he did not demand or he did not request, it is not the duty of the committee to give him advice and ask him to bring witnesses. Yes. Now paragraph 9, page 108. What is his final stand? He is highly satisfied with the committee. 108, page number, serial number 7. In view of the facts and circumstances stated above, the complaint dated 19/4/2017, 2014, as well as 11/6/2019 filed by the complainant are devoid of any merit, and therefore complaints are not filed mala fide and has been with oblique motive of harassing me for being elected as a parliamentarian. Therefore, initiation of proceedings against me is liable to be closed, upholding my social status as Boro Kochari, and the tribe certificate dated 12/10/2011 issued by the Nalbari District Tribal Congo is a valid one. This is my additional reply to the so-called notice dated 11/3/2020. I am grateful to the respected chairman and the members of the state level Caste Scrutiny Committee for giving me a patient hearing for the cause of justice. So what more is required? If he gave us the certificate that you have done a good job.
now arguing, Lordship, that he was denied opportunity of natural justice, the principle of natural justice are being violated, will not hold the field. And this certificate comes from none other than a member of the parliament for 2 times. We have to respect their status also. It is not from any Tom, Dick, and Harry.
I think this mala fide should have been bona fide. That concession perhaps he deserves. That mala fide word, third line. It'll make you
Not file malafide. They are all saying he's giving certificate to my learned friend's client.
No, I think this should be bona fide.
Bona fide.
Let us give the
Absolutely,
concession.
I have to agree, Lord. But
Because
last line, the whole sentence cannot be
last line we
typographical
agree,
error.
but the first part
Oh, yes.
does not devoid of any merit. Then second part has been filed with oblique motive of harassing me, then but not mala fide.
Not malafide.
Mr. Sarani,
He will say that I was not the advocate. He will directly say that.
there is a vast difference between MALA and
Lord,
BONA.
Sometimes it happens.
Computer. My lord.
Malafide
checking
cannot
the
become bona fide
computer,
by computer, Lord.
When it shows it's correct, but Malavadi, not Malavadi, both are correct. After that, but we have to read with the whole sentence.
That is why we are saying we are giving concession.
My lord.
We'll read mala fide as bona fide.
So, this was the reply.
But he clearly admits that a fair hearing was given to him.
Yes, Lord. But more is
That
required.
transpires. And you have also trying to emphasizing that as per 13.6, the arguments which have been sought to be developed,
Yes.
you will emerge at a situation when he seeks a
Absolutely.
hearing opportunity as well as an inquiry.
Absolutely.
The second part of constitution of a committee to have an inquiry done is only on an request made by him.
Absolutely, Lord.
He has made for a request for hearing you have done. So the inquiry would perhaps require cross-examination, which he has not
Demanded.
he has not requested. And he appears to be satisfied with the
Yes. Whole process. Whole
process
exercise.
wherein he was given a hearing and opportunity to file an additional reply also.
Lordship.
Okay. Interesting.
Shall we continue with 2 or
5 minutes.
5 minutes?
How long will you take?
I'll only the impugned order I have to place.
That is yet to be placed.
Yet, because there it has been admitted. Speaking order.
This was a
Let me finish it.
this
I'll
was-
finish it in 2 minutes. Before 5 minutes, I'll.
Okay, then perhaps we can hear Mr. Das then.
No, the facts I will place and I will take half an hour for my arguments.
Okay. Finish the facts then.
Yes.
Page
Page 111,
111.
111, Annexure
Yes.
27,
Nelson.
12 January 2024, speaking order. The first page is the narration.
12 January. This is
Yes,
the
12
this is
January.
the order impugned.
This is the fourth prayer
Okay.
of challenge.
12 January.
Yes. I am reading, Lordship, second paragraph from top in page 112. Whereas Nobo Kumar Korania petition dated 8/4/2020 and 18/6/2020 sought extension of time to submit his replies. Later, he submitted the replies on 31/8 to his SOCOS to the director WA. Whereas Janaklal Kusne submitted his reply to the SOCOS notice on 21/9/2020. Whereas the CID in the meantime submitted their second report, file number 40/2020. Whereas on receipt of the second report, Vigilance Cell held a meeting on 14/9/2020 and decided to refer the case to the state level scrutiny committee dated 18/9/2020. Whereas the state level scrutiny committee was held on, whereas the hearing of the state level scrutiny was held on 11/11/2020,
Yes.
the committee heard Nobo Kumar Koronia in person. Notable, kindly note that.
Yes, yes.
And Peruzzi stand as reply dated 31/8/2020 to the SOCOS notice submitted to the director. Whereas the state level hearing committee was held on 4/12/2020, wherein the committee heard Jonaklal Bosumatre in person. The Jonaklal Bosumatre submitted another written statement on that day, which was perused by the committee.
Then there's some report, there's some opinion from us, Lordship. We did not give any opinion because the matter was submitted. Now, page 113, last paragraph. Whereas the SLSC examine in detail the findings of the Vigilance Committee, which are as follows. The STP, etc. These are all narrations
Yes,
of the same thing.
It's a
10
quote-
points they have.
Quotation of the inquiry
Yes.
report.
But the relevant portion, not all. Quotation of 10 very vital points here.
Okay.
Lordship will see, for example, 10 ... it start, which shows. So the relevant portions are quoted there.
Yes.
Like one example, I can give serial number 3.
Conformity.
Sri Dipannita Koronia, sister of Nobo Kumar Koronia, stated that she has STP certificate and she and her family belongs to Koronia community. And her father used to write Das, etc. All these things, the employment certificate, school certificate, the Gambura's statement, post community belonging, all these things are narrated here. The NRC legacy data, the land cheater register, everything, Lordship. And how the land records were corrected by inserting Porukuch. And finally, the report of the vigilance officer, etc. Now coming to the operative portion, where SLSC committee, after careful perusal and examination of the written statement, documents, certificates, etc., submitted by Nobo Kumar Koronia and Jonoklal Bosumatari, and the report submitted by the Vigilance Committee is of the view that Sri Nobo Kumar Koronia does not belong to Boru Kochari community. They have come to one conclusion that he does not belong to, or he is not from Boru or Boru Kochari community. Whether he belongs to Koronia community or not, that is not the opinion. He may become OBC also. If he is a coach, he will become OBC. But that is not the finding of this committee, and all the 5 members have signed. So this committee's categorical finding is that Nobo Kumar Koronia does not belong to Boru/Boru Kochari community, which are included in the Presidential Order of 1950.
Okay, we'll come back. Is it dated 18th of March?
Yes, Lord.
Okay.
It starts from page 128. Paragraph 5 I have already placed. 7, there is one report of the Lordship post.
Paragraph 5.
Paragraph 5 I have placed in the very beginning today.
Yes. Yes.
Then paragraph 9, second line, copies of the documents are furnished to the petitioner as necessary under the procedure. Whatever documents he asked us, we gave, whatever was available. To
That
the
is in
record.
paragraph 9.
Paragraph 9.
Where page?
Page 132, second line, copies of the documents are furnished to the petitioner as necessary under the procedure. And focus notice reference.
Second line, copies of the documents.
Then paragraph 10, third line from below.
132.
The petitioner never objected regarding the constitution of SLSC, nor he has ever raised any objection regarding the validity of the committee. And on the contrary, the petitioner has initially sought extension of time to submit his reply written statement pursuant to the notice, pursuant to receiving the so-called notice dated 11/3/2020. Then 4 lines below, the petitioner was given ample time to submit his so-called reply by the committee, and the petitioner has submitted his reply accordingly. Further, the petitioner has filed an additional written statement on 21/12/2020 before the SLSC with regard to the so-called notice dated 11/3/2020. And here also the petitioner did not object to the constitution of the SLSC Vigilance Committee, and the petitioner continued with the proceedings. Then paragraph regarding one of the contention that on 12/1/2024, while passing the speaking order, there is no minutes of the committee.
Yes.
That we have stated, fourth line, no minutes were recorded on 12/1/2024 as speaking order was passed by the SLSC on the same day, and the same was signed by all the members of the committee. in the speaking order itself is final order of the proceedings and the same was passed on 12/1/2024, requirement of another minute was not required to be kept in the proceeding. Then paragraph 12, second paragraph, according to them, there is a second report. Our statement is like this. The alleged second report as alleged by the petitioner is in fact is not a second enquiry report, but a continuation of the initial report of 23/10/2019, which was inconclusive. So the Vigilance Committee further continued the enquiry to be made by the same Inspector of Police CID who had conducted the initial enquiry, and the conclusive report was sought by Vigilance Committee cell as the first report did not carry out the enquiry as per the guidelines as per Madhuri Patil judgment dated 11/5 and as well as the guideline of 11/5/2018. Mayor perusal of both the reports will indicate that both the reports is a single report and was submitted by the same Inspector of CID before the SP CID on 4/2020. Then paragraph 14, we have mentioned about the two directorates and the Director of Tribal Affairs, all these things. And paragraph 15, they have the grounds in their writ petition. Ground-wise, we have given our reply. The main replies are paragraph 2 regarding the constitution of SLSC, the committee, paragraph 2, Roman to 15:2. Then 3 and 5 regarding the research officer, because they alleged that the concerned person, Ganesh Chandra Kakoti, did not have the qualification. We gave him his whole credentials. The Ganesh Kakoti has guided research in conducting 35 research topics and more than 60 seminal topics, etc. Full details we have given. He is the author also of several books relating to tribes and tribal culture practices. This is 3 and 5. Roman 5 also, details of Ganesh Chandra Kakoti.
He's the expert.
He's the expert in the paragraph 5, may I read it? It is not admitted.
He's otherwise, what was the post which he was
He
holding?
was joint director of Assam Institute for Research of Tribal and Scheduled Caste.
That ART.
Yes, Lordship, ART and SC. According to them, he is just a civil servant. No, he is not just a civil servant. He had the credentials of having, he has a postgraduate degree in anthropology and has been working in the ARSCT since March 1996.
Okay.
He has been guiding research officer in conducting ethnographic research on other socio-economic issues on scheduled tribes of Assam and organized seminars, workshops on various issues relating to SC and SC. So far, Kakoti has guided research officials in conducting more than 35 research topics and more than 60 seminar topics. Kakoti has also been preparing reports on the memorandum petitions submitted by various communities that offer necessary views, suggestions on their grievances to the government for further necessary action. Kakoti has also authored the following book: Material Cultural Heritage of Tribes of Assam, a catalogue on museum collections published by Assam Institute of So-and-so. And co-editor of Purbanchal Bhasha Sahitya and Sanskriti by the same institute. Then co-author of the Thengal Kosaris of Assam. AIRDC and SC is a premier institution under government of Assam created for research, evaluation, planning and training for scheduled tribes and scheduled castes. All officers of the institute are from anthropology background, having postgraduate doctorate degrees. These officers have intimate knowledge of tribal communities. The institute has published more than 200 books on cultures, traditions, and ethnography of tribes of Assam, and many audiovisual documentaries. The institute carry out on average 15 to 20 number of research studies, seminars, workshops every year. So this is our response to that part. Regarding the vigilance cell, Lordship, we have stated 6 regarding the constitution. Then There are repetitions, so we are also repeating the same thing. Roman 16 at page 143. We have mentioned it would be incorrect to say that the initial inquiry report dated 23/10/2019 was in favor of the petitioner. It was a preliminary report which suggested that the petitioner is from Poronia community which falls under SCP of Assam, whereas the fact remains that the Constitution Schedule Order 1950 do not confer Soronia or Soronia Kosari as the scheduled tribe of Assam. The Constitution Scheduled Tribe Order Bill dated 2011 referred the same to the state government for further justification on the comments of RTI on 5/5/2006 regarding Poronia Kosari. Further, the government of Assam WPT and BC Department, now known as the Department of Tribal Affairs, has submitted an affidavit before the Honorable Court clarifying that Poronia Kosari has not been enlisted in the ST list of Assam as per the Scheduled Caste and Scheduled Tribe Order as amended from time to time. And the Honorable High Court in WPC passed an order dated so. Observe that I have also perused the list of Scheduled Tribe Incorporated Central Order 22 and prima facie it appears to me that the Soronia is not enlisted tribe, so the tribe certificate has been issued to respondent number 7. That at a later stage the petitioner was withdrawn, but the fact remains that till today Poronia Kosari community has not been listed in the ST list of Assam as per the Scheduled Caste and Scheduled Tribe Order as amended from time to time. Then 17 is the petitioner was given proper opportunity to defend his case. That's stated. Then paragraph 16, we have stated what are the basic documents while we have considered. The answering deponent begs to state that on examination of the school record, evidences given by witnesses during inquiry, land record, NRC, etc., the SLST came to the conclusion that petitioner does not belong to Boru Kochari and stated the scheduled tribe in the state of Assam and SLST has passed the speaking order on 12/1/2024. I missed one, Roman 4 at page 138 regarding the deputy secretary inclusion in the as member secretary. We have stated it is not admitted that Deputy Secretary WPT and BC Department is not nominated member of SLST, hence request for inquiry is illegal. Due to frequent changes in the administrative setup, due to transfer or promotions in that the department at times functions without joint secretary. In such cases, Deputy Secretary functions as the member secretary. So there is no derogation of power when sometimes the Deputy Secretary discharges the function of the joint secretary also. These are temporary things. So now, I would like to refer to some judgment of the Supreme Court which I would like to rely upon. And finally, whatever was their argument, I will give the counter to close my subject. 2001, Volume 1, SCC, page 4. It's a Constitution Bench judgment, State of Maharashtra versus Milind and others. Paragraph 15, paragraph 28, paragraph 36, 1.
15?
15, 28, 36. 36, 1. Paragraph 15, may I please it out?
15. 20, 50.
Paragraph 15.
Yes.
Internal page will be Lordship 18.
1-8.
1. Thus, have Lordship of it. Thus, it is clear that states have no power to amend presidential order. Consequently, a party in power of the government of the day in a state is relieved from the pressure or burden of tinkering with the presidential order, either to gain popularity or secure votes. Number of persons in order to gain advantage in securing admission in educational institutions and employment in the state services have been claiming as belonging to either scheduled caste or scheduled tribe, depriving genuine and needy persons belonging to scheduled caste and scheduled tribe covered by the presidential order. defeating and frustrating to a large extent the very object of protective discrimination given to such persons, people based on their educational, social backwardness. Courts cannot and should not expand jurisdiction to deal with the question as to whether a particular caste, subcaste, a group or part of tribe or subtribe is included in any one of the entries mentioned in the presidential order issued under Article 341 and 342, particularly so when in Clause 2 of the said article, it is expressly stated that the said orders cannot be amended or varied except by law made by the Parliament. The power to include or exclude, amend or alter presidential order is expressly and exclusively conferred on and vested with Parliament, and that too by making a law in that regard. The President had the benefit of consulting the state through governors of the state, which had the means and machineries to find out and recommend as to whether a particular caste or tribe was to be included in the presidential order. If the said order are to be amended, it is Parliament that is in a better position to know, having the means and machineries, unlike court, as to why a particular caste or tribe is to be included or excluded by law to be made by Parliament. Allowing the state governments or courts or other authorities or tribunals to hold inquiry as to whether a particular caste or tribe should be considered as one included in the schedule of the presidential order, when it is not so specifically included, may lead to problems. In order to gain advantage of reservations for the purpose of Article 15.4 and 16.4, several persons have been coming forward claiming to be covered by presidential order issued by Article 341 and 342. That effort, when no other authority other than the Parliament.
This you can skip. There's no ambiguity. The
Yes, Lordship.
presidential orders
therefore,
cannot be tampered with.
yes, nobody
the
can
state.
tinker.
Mm.
28
To it.
Wait. Being in respectful agreement, we reaffirm the ratio of the two constitution bench judgments aforementioned and state in clear terms that no inquiry at all is permissible and no evidence can be let in to find out and decide that if any tribe or tribal community or part or group within any tribe or tribal community is included within the scope and meaning of the entry concerning the presidential order, when it is not so expressly or specifically included. So this is my case, Lord, that Boru and Boru Konsari are only included here. So whether Soronia Kosari or whether some subcaste falls under Boru Kosari or Boru, that evidence cannot be looked in. That is why that 2011 amendment was sought. And the Parliament till now has not given the green signal. So 28 is very clear that no evidence is required also to be laid for that purpose, because that exercise is to be done through a different machinery mechanism. Paragraph 36(1) says, in the light of what is stated above, the following positions emerge. It is not at all permissible to hold any inquiry or let in any evidence to decide or declare that any tribe or tribal community or part or group within any tribe or tribal community is included in the general name, even though it is not specifically mentioned in the entry concerned in the Constitution Schedule Tribes Order 1950. Had Soronia Kosari been included as Boru Kosari Lordship, in that case, that exercise of having that particular amendment proposal in 2011 was not necessary at all. The competent and the expert bodies have opined that they also falls under scheduled tribe. Therefore, that attempt and proposal was mooted. But finally, till now, the amendment has not been granted. Once it will be granted, then there will be no issue. It will not be a live issue thereafter. Coming to another judgment, AIR 1965, Supreme Court 1557, Hayalal versus Harikishan Singh, paragraph 8.
1990.
1960, AIR 1965, Supreme Court 1557. Paragraph 8. Incidentally, we may point out that the plea that Dohar caste is a subcaste of Chamar caste cannot be entertained in the present proceedings in view of the Constitutional Schedule Order 1950. This order has been issued by the President under Article 341. Article 341(1) provides that the President may, with respect to any state of union territory, where in the state after consulting the governor, by public notice specify the caste, races, tribe, part of or group within caste, races, tribe, which shall be for the purpose of this constitution be deemed to be the scheduled caste in relation to that state or union territory, as the case may be. Article 2 lays down that Parliament may by law include or exclude from the list scheduled caste specified in a notification issued under clause 1 of any caste, race, tribe, or any part of or group within any caste, race, tribe, but save as aforesaid in a notification issued under the said clause shall not be varied by any subsequent notification. It is thus clear that in order to determine whether or not a particular caste is a scheduled caste within the meaning of 341, one has to look at the public notification issued by the President in that behalf. In the present case, the notification refers to Samar, Jatav, or Mochi. And so, in dealing with the question in dispute between the parties, the inquiry which the election tribunal can hold is whether or not by the appellant is a Samar, Jatav, or Mochi. The plea that though the appellant is not a Samar as such, he can claim the same status by reasons of the fact that he belongs to Dohar caste, which is a subcaste of the Samar caste, cannot be accepted. It appears to us that an inquiry of this kind would not be permissible having regard to the provisions contained in Article 341. In case of so-and-so, 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 this court had occasion to consider a similar situation. The question which arose for decision is that case was whether respondent number 1, though voter by caste, belonged to the scheduled caste of Hovi mentioned in the order, and while holding that an inquiry into the said question was permissible, the court has elaborately referred to the special and unusual circumstances which justify the High Court in holding that the voter caste was the same as Hovi caste within the meaning of the order. Otherwise, the normal would be. It may be accepted that it is not open to make any modification in the order by producing evidence to show. For example, to caste A alone is mentioned in the order, caste B is also a part of the caste A, and therefore must be deemed to be included in caste B. That is another reason why the plea made by the appellant that Dohar caste is a subcaste of Samar and as such must be deemed to be included in the order cannot be accepted. So here
There has
also
to be a
all these
specific-
exercises are meaningless. in
There
my-
has to be a specific mention of the caste.
Exactly.
Some caste, subcaste if not mentioned.
Any authority other than the parliament lordship
Okay.
cannot enter into that area
Hmm.
to give any implied meaning. 1994, page 1 SCC, page 359. Palghat Tila Thangan Samudaya versus State of Kerala, paragraph 18. 18 and 20. More or less the same principle here. 18 says, these judgments leave no doubt that the scheduled caste order has to be applied as it stands.
Yes.
As it stands, and no inquiry can be held or evidence let in to determine whether or not some other particular community falls within it or outside. No action to modify the plain effect of the scheduled caste order except by Article 341 is valid. 20 says, it is basically the same thing, lot of other cases. Yes, lot of, this is relevant case here. The Learned Council of the State relied upon the decision of Bhayaram versus Anirudh Patar, referred to in paragraph 15 of the judgment in Sri Kumar Chaudhary's case. For the view taken there was that evidence was admissible for the purpose of showing what an entry in the presidential order was intended to mean. In para 8, 9, 10, and 11 of the judgment of Sri Kumar Chaudhary's case, the Constitution bench referred to above or discussed as also other judgments taking the same view. Then in paragraph 14, the judgment of this court in the case of Dina versus Bhayaram are referred to, and it stated that both are rendered by the same bench of two learned judges. Paragraph 14 goes on to set out the substance of the decision of Dina case, and paragraph 15 sets out the substance of the decision of Bhayaram case. In paragraph 16, it is said These authorities clearly indicate, therefore, that the entries in the presidential order have to be taken as final, and scope of inquiry and admissibility of evidence is confined within the limitations indicated. It is, however, not open to the court to make any addition or subtraction from the presidential order. There is therefore no doubt that the court in so and so accepted and followed it as it was bound to do. The Constitution bans judgment and not to judgment in deny and bias. So this all of some tribal Congo cannot do it, Lord. The Supreme Court says that Honorable Court can also not enter into this domain. In that area, Lordship, when the name is not there, when the background check is not there, the records are not there, Lordship, on what basis they have given him the status of Borukachari? So this is the case, Lord. (1996), 3 SCC, page 576. Nityananda Sharma versus State of Bihar. I will read one lines from
1996, 3 SCC.
Page 576. Nityanand Sharma versus State of Bihar. Paragraph 15, 18, 19, and 28. Paragraph 15 says, it is for Parliament to amend the law and the schedule and include and exclude from the schedule a tribal or tribal community or part of or group within any tribe or tribal community for the state, district, or region, and its declaration is conclusive. The court has no power to declare synonyms as equivalent to the tribe specified in the order or include or in substitute any caste, tribe, etc. It would thus be clear from the purpose of Constitution, schedule type defined in Article 366(25) as substituted under this act, and the second schedule thereunder are conclusive. Though evidence may be admissible to a limited extent of finding out whether the community which claims the status as scheduled tribe or scheduled caste was in fact included in the schedule concerned, the court is devoid of power to include in or exclude from or substitute or declare synonym to be a scheduled caste or scheduled tribe or part thereof or group of such caste, subcaste, or caste or tribe. Then paragraph 18. Basically similar 18, 19, and 28. 18 and 20. 18. 18 and 20.
Yes.
One judgment, but I don't think it will be very relevant. But 2021 9 SCC page 804.
What is the proposition?
Proposition said once the Caste Scrutiny Committee disallows it, then all the benefits he should give up. Once the claim of the appellant that he belonged to Halba stood negated by the Caste Scrutiny Committee, no advantage can thereafter be extended to the applicant.
Consequence of cancellation.
Yes.
That doesn't matter.
The other day, Lordship, one judgment was relied upon by the petitioner's side, Lordship, very recent judgment of Court of March.
Maharashtra case.
Yes, that Navneet Kaur case versus State of Maharashtra. That case, the other side referred to paragraph 10, if I'm not wrong. I am not on that part. Regarding the procedural part, Lordship, in this case, in Maharashtra, there is the act as well as there are rules in operation. Therefore, after the SLSC committee is Lordship, the Vigilance Committee can start an inquiry. All these things are reversed, unlike Madhuri Patil's case. This case, Navneet Kumar, but certain observations are applicable whether we follow the Madhuri Patil principles for the state government's notification of 2018 regarding conduct of inquiry vis-a-vis the procedures laid down under the Maharashtra Act. His judgment, Lordship, is pleased to look at that there is a law in force. They have framed a law in Maharashtra after the case, and there is reference to all these things. Like paragraph 10, third Lordship. At the present case arises from Maharashtra, it is necessary to deal with the respective state act, that is Act of 2000, enacted with effect from 18/10/2010, containing elaborative procedures and mechanism for regulation and verification of caste claims. So, section 6 says verification of caste certificate by scrutiny committee. Section 7 says confiscation and cancellation of all certificate. 9 says civil court power, etc. Then 13 says report of vigilance cell and issues to be dealt with. Rule 13. Rule 14, verification of caste certificate. Rule 17, procedures of scrutiny committee. That way, Lordship, at paragraph 11, this is the paragraph they had relied upon. A combined reading of the section of 2000 Act and rules of 2012 makes it clear that a detailed procedure has been prescribed for the scrutiny committee to deal with the claim of an applicant for validation of certificate. So, detailed procedure is there. That procedure is not same as the procedure under Madhuri Patil or under the state notification. But certain observations which, because they relied upon paragraph 12 and says that once this state level verification committee comes to the conclusion that inquiry is required, then the vigilance officer and vigilance committee will start acting. So it is the reverse role there in Maharashtra. Here, first the vigilance exercise is done, then the SLSC takes over the inquiry. It is just the other way around in case of Maharashtra's Act and Maharashtra's rule. But the observations which I would like to rely upon here are paragraph 15. 15, 17, 19, 22, 23 and 24 also. Paragraph 15. When the scrutiny committee, which is principally tasked with the fact-finding exercise for validity, internal page 13.
Yes.
When the scrutiny committee, which is principally tasked with the fact-finding exercise for validation of caste claim, had applied its mind and reached a conclusion, then in such a situation, whether a roving inquiry by High Court was required. This is the area where I am trying to emphasize. Whether the High Court, where roving inquiry by High Court was required. It is well settled that the High Court as well as Supreme Court should refrain themselves from deeper probe into factual issues like an appellate body, unless the inferences made by the concerned authority suffered from perversity on the face of it and or impermissible in the eye of law. In the instant case, the order passed by the scrutiny committee reflects due appreciation of evidence and application of mind, and in absence of any allegations of bias, malice, or lack of jurisdiction disturbing the finding of scrutiny committee cannot be sustained. Pausing here for a moment, there is no allegation of bias. Great. There was no argument I have heard. No no allegation of arbitrariness. No allegation of unreasonableness. They have not said that this particular document is fake, this particular is not sustainable. Nothing of that submission have ever come before this honorable court during the course of hearing. So there is no allegation of bias, malice, lack of jurisdiction. Constitution of the committee they have challenged here, but before that also not. That I am trying to satisfy this honorable court that there is no irregularity or illegality in the constitution of the committee also. So in that case, whether the Honorable High Court would look into the various factual aspects, that is the area. Now coming to 17. Having perused the order passed by the scrutiny committee and findings recorded by it to reach its subjective satisfaction with respect of the claim of the appellant, at this juncture, if we look at the whole exercise carried out by the High Court from the perspective of settled principles of law for invocation of the jurisdiction under Article 226 of the Constitution of India, particularly in relation to writ of certiorari, it leaves us with no scope for doubt that the High Court has clearly overstepped by reappreciating the evidence in absence of any allegation of malafide or perversity. As fairly settled by this court in Catena of Judgments, the writ of certiorari, being a writ of high prerogative, should not be invoked on mere asking. The purpose of a writ of certiorari for a superior court is not to review or reweigh the evidence to adjudicate unless warranted. The jurisdiction is supervisory, and the court exercising it ought to refrain to act as an appellate court unless the facts so warrant. It also ought not to reappreciate the evidence and substitute its own conclusion, interfering with the finding unless perverse. There is no allegation of perversity also in our instant case, Lord. The High Court in a writ of forgery should not interfere when such challenge is on the ground of insufficiency or inadequacy of material to sustain the impugned findings. Assessment of adequacy or sufficiency of evidence in the case in hand fail within the exclusive jurisdiction of the Scrutiny Committee, and re-agitation of challenge on such grounds ought not to have been entertained by High Court in a routine manner. Paragraph 19. In sum and substance, a court of certiorari is expended as a remedy and is intended to cure jurisdictional error, if any,
You're
committed by
reading 19.
last two lines. In sum and substance, the writ of certiorari is expended as a remedy and is intended to cure jurisdictional error, if any, committed by the court forums below. It should not be used by superior court to substitute its own views by getting into fact-finding exercise unless warranted. In the case and so. At this juncture, it would be profitable to refer relevant extracts from judgments delivered by this court in Indian Overseas Bank, wherein it was observed thus as the finding of fact recorded by a fact-finding authority duly constituted for the purpose and which ordinarily should be considered to have become final cannot be disturbed for the mere reason of having been based on materials or evidence not sufficient or credible in the opinion of the writ court to warrant those findings at a rate, as long as they are based upon such materials which are relevant for the purpose, or even on the ground that there is yet another view which can be reasonably and possibly undertaken. Being being the situation in the instant case, the High Court went into probe regarding credibility of the opinion of the Scrutiny Committee because the writ court felt the need to substitute its own views. In case if the findings of the Scrutiny Committee are based on materials specified under Rule 16, followed by its subjective satisfaction, then exercise of jurisdiction under writ of certiorari to pass the order of validation of tasks claimed by Scrutiny Committee is unwarranted and uncalled for. Till now, Lordship, I have not heard anything from the other side that a particular document is not correct. Whatever factual statements were obtained from those documents during the verification exercise, Lordship, they have not been able to highlight a single error in those documents, like the NRC data, like the school certificate, like the certificate or the statement our sister said, the report of the first report given by the police officer. They have not alleged anything against all these things. They have not said these reports are incorrect also. So factually, all are admitted. So in that view of the matter, whatever opinion the Scrutiny Committee has given, Lordship, they cannot allege any kind of malafide, bias, or perversity. So in that situation, Lordship, a writ of certiorari is not warranted in my humble submission. Coming to paragraph 22. In view of the aforesaid discussion, we have the considered opinion that the High Court inadvertently undertook an erroneous exercise of appreciating evidence in exercise of its jurisdiction under Article 226 of the Constitution, and swayed itself into a roving inquiry which was not expected as per settled legal position. At the cost of repetition, we again observe that under Rule so-and-so of 2012 rules, the adjudication on the basis of documents falls solely within the domain of the Scrutiny Committee based on the input received from the Vigilance Cell. The Scrutiny Committee is an expert forum armed with fact-finding authority. The High Court ought not to have interfered, especially when Scrutiny Committee had followed the due procedure. Stopping here. under Rule 12, 17, and 18 of the 2012. Instead of that, in our case, it will be as per the guidelines of Madhuri Patil and OM dated 18/5/2018. Just that is the replacement I am saying. Because in Maharashtra, there is a special act and a special rules. So the High Court ought not to have interfered, especially when Scrutiny Committee had followed the due procedure under Rules so and so of 2012 rules, and that there was nothing perverse about a finding of a fact. Next page, Lord. In the instances, the Scrutiny Committee duly considered the documents placed before it, and after due application of mind on being satisfied, accorded reasons for accepting validating the caste certificate claim of the applicant herein while accepting rejecting other certain documents. The Scrutiny Committee heard all the parties in detail complying with the principle of natural justice. In our considered opinion, the order of Scrutiny Committee did not merit any interference by the High Court in a writ of certiorari under Article 226 of the Constitution of India. These principles squarely covered our. So far as the question of judicial scope to tinker with presidential orders, there is no quarrel that presidential order cannot be amended directly or indirectly. So this is a settled position. And here also, the Honorable Court said that all the parties were heard. Here also, all the parties were heard. So this judgment, rather than helping the other side, it is helping the state. So these are basically the judgments which I would like to rely. And finally, I would like to address the arguments made by them. I would like to give a copy of that also. So,
You please give a copy to Mr. Sarani.
yes. Just in a there is a submission that the petitioner relies upon paragraph 31, 32 of the order dated 3/4/2024 by writ appeal 110. So let us go there. The other side is relying upon paragraph 31 and 32. So I would like to refer to paragraph 25, 26, 27.
Okay.
This was the writ appeal filed against the interim order. So they refer to 31 and 32. But before that, I would like to take this honorable court to paragraph 24, 25, in fact 23 also. So it is not very relevant. Let us start from 25. So far as the question of recording of reasons by SLSC.
Yes. Yes.
Their contention basically was that the impugned order does not have reasoning and it is not a speaking order in proper format. This is their contention.
Right.
And the division bench said because they have brought the division bench order, so therefore we'd also like to bring the division bench order before this honorable court also. So far as the question of recording of reasons by SLSC is concerned, after perusal of the order dated 12/1/2024, we feel that SLSC has taken into consideration the report of the vigilance officer, the responses filed by the respondent number 1, the available document, certificate, etc., submitted by the respondent number 1, and the complainant, as well as other materials available on record, which were placed reliance upon by the SLSC. It is another question as to whether the reliance placed by the SLSC on the report of the vigilance officer or the documents, etc., produced by the parties and the written statements submitted by the respondent number 1 are in accordance or with law or not. However, in our considered view, the order of the SLSC at the first instance cannot be treated as non-speaking order. In the beginning also, Lordship, I have said that they have given the reasons. They have highlighted 10 special points
there are thousands of documents before the committee, but the committee referred to those parts which are relevant for coming to the conclusion that he does not belong to Boru Kochari. So the division bench also opined that it is not a non-speaking order, it is a speaking order. Paragraph 26. So far as question of regarding personal examination of respondent number 1 by the vigilance officer is concerned, it is to be noted that the primary responsibility of the vigilance officer is to conduct a fact-finding inquiry and submit a report. If the finding of facts projected in such report remains unrebutted by the contestant, then in that event, it will be open for the SLSC to form an opinion by taking cognizance of such report. After going to the paragraph 13.5 of the Madhuri Patil, it can therefore be stated in every case, personal examination of the candidate or even the parents, guardians, or other relatives is not mandatory. In paragraph 30, their allegation was that the concerned person was not examined by the vigilance officer, not by the SLSC. In that situation, the Honorable Court said, in fact, it is not mandatory. It is only when there is no other incriminating evidence available before the vigilance officer, he should personally examine the candidate or the parents or other relatives of the candidate. In the given case, the vigilance officer is able to collect evidence which, as per his own assumption, is sufficient. He may or may not personally examine the candidate or other person. 27. It is true that SLSC has not issued any notice to the respondent number 1 providing him opportunity to adduce evidence. But it can be gathered from the two responses filed by the respondent number 1 that he did not demand any opportunity for adducing evidence, though he had requested for personal hearing by the committee, and that request was accepted and the respondent number was personally heard. In the so-called notice issued to the respondent number 1, it is clearly mentioned that the respondent number 1 can submit his explanation within the stipulated time or can desire for a personal hearing. The respondent number 1 had been a member of the parliament for 2 terms and is not a layman. If he desired to adduce any evidence, he was free to adduce the same without even issuance of specific notice to that effect by the SLS. As a matter of fact, in his last response, the respondent number 1 has expressed his gratitude towards the chairman as well as the members of the SLSC for giving him patient hearing.
You have shown this.
I have
this
shown it,
part.
but these are the observations of the Honorable Court also. Therefore, those violation of the principle of necessity will not hold the field. Then 31, 32, Lordship, the other side said, so it has nothing to do. Then according to them, STP certificate of the petitioner wherein he was declared as Boru Kachari and not insisting Sarania are not tribals, but Boru Kachari who took Saran remain Boru Kachari. Certificate issued on 12/10/2011 to the petitioner, but the notification to ensure that the Sarania has been given status of tribal was given through notification date 5/6/2018, which was subsequently withdrawn by the government, will have no impact on the petitioner, and he will remain a Boru Kachari. In response to this submission, my stand will be, mere issuance of a certificate to a person showing him to be a member of STP cannot be sustained without backup evidence that his ancestors' parents belonging to the same community as claimed by the petitioner. Admittedly, the petitioner could not produce a single document which would indicate that his parents belong to the Boru Kachari community, or on the contrary, all the documents his parents indicated that they belong to Deka, Porukus, Das, surname, and further, as per the statement of the petitioner's sister, Sri Dipanita Horonia, reflected that petitioner's family belongs to Horonia community. All the educational documents of the petitioner could not establish that the petitioner belongs to Boru Kachari community. Rather, in his school register of Tamulpur, petitioner's name was recorded as Nomo Kumar Deka and certificate of the that is recorded as Nomo Kumar Horonia. Further, it is pertinent to mention that the petitioner applied and received his so-called STP certificate on 12/10/2011 at the age of 41 years before contesting his first election. At present, his present age is 53. So, till 41 years, he never applied, and he could not produce a single document to establish that he or his family members belong to Boru Kachari.
That was the question which you had put
Yes.
yesterday.
Yes,
that
Lord.
prior to 2011,
Yes, Lord.
is there any materials, maybe
Yes.
documents, maybe some other,
Absolutely.
where the petitioner or any of his close family members
Lord.
had availed
Lord.
the benefit of
Lord.
belonging to the scheduled tribe plains?
Lord. So,
Mr.
they
Khurshid
have
has
failed
said that
to-
he will take instructions on this.
Yes.
We'll ask
Yes.
him.
So now the question is that this particular SLSC committee has opined that he does not belong to Boro Kachar. But the committee has not opined that he belongs to Soronia Kachar.
That is immaterial.
That is immaterial. That is what I am trying to emphasize.
That is
Lordship.
immaterial.
The other side, they are saying that Soronia also belongs to ST
No,
Boro
that was not
Kachar.
the
All these
submission.
things are good.
That was not the submission yesterday. The
Fine,
certificate,
Lordship. Then I
certificate
withdraw
says
my.
Boro Kachari,
Hmm.
the submission is that this certificate has been cancelled without following the fair procedure as laid down in Madhuri Pratil,
Lord.
and it was expanded.
Lord. If that is the question, then that paragraph itself is the answer. Paragraph 13(6). In two reports, Lordship, I have said the second report is a continuation of the
Continuation.
first report, and the first show cause notice was issued after both the reports were there. And the first report does not have any details of any of the lineage or the various categories or parameters which the Madhuri Patil's case indicated, as well as our office memorandum indicated that school, their lineage, their practices, tribal practices, the affinity test, all these things are indicated in that paragraph, and that was not done. Only thing that was done was that it was based purely on that notification of 2018, which was subsequently withdrawn. They have heavily relied upon the first report, that means the October's report of 2019. That report, in fact, is in favor of the state's contention that he belongs to Horonia community. If they are agreed and if they are supporting that document, then Lordship, they have to support Horonia community also there.
Which is not a part of the central law,
presidential order.
Central Order 22.
Absolutely, Lordship. So they cannot agree to the findings that he belongs to SPP and without taking the facts which were stated in the first paragraph 2. It cannot be partially accepted, partially rejected. Either you have to accept it in toto or you have to wholly reject it.
Okay.
Then second report, they want a speaking order that is not required, Lordship, because after the second report was submitted, the Vigilance Committee made the minutes they themselves have annexed 14(9), Lordship, and it was decided that the matter will be referred to the SLSC. Regarding 3 members committee, 5 members committee, I have already placed, Lordship. The Supreme Court has also clarified that and amended in 1997 by the judgment of 1997 5 SCC 437 that the number of members can be increased from 3 to 5 in a committee, and in Maharashtra 3 committees can be constituted considering the size of the state. Then regarding the police officials present in the SLSC, the SP CID
Yes.
was included.
Yes.
When the Honorable Supreme Court increased the number from 3 to 5, that what will be the 4th member and 5th member, there is no indication.
That you have already argued.
So
No, what
I'm
was
just referring.
the final point which was argued by Mr. Khurshid is that since the vigilance cell, since the investigation was done by an officer under the SP, so the SP being a part of the committee would not may raise certain suspicion regarding the fairness in the procedure. That is the argument.
That argument will not hold because the SP himself is not doing the verification.
That we have thought about.
Yes. Yes.
But
He is not the inspector, he's a lower level officer. In any case, Lordship, the SP will always have to monitor in any kind of investigation. Yes, suppose normal police case, the criminal case, the SP does the IO does the thing.
investigation.
And finally, it was when the charge sheet is forwarded, it is always the SP who will have to finally give the endorsement before filing of the final report or the charge sheet. So that is the procedure. So it does not mean that they sail on the same footing. Lot of cases the SP interferes, and here he is not the single person. There are four other persons who are expert in the field. In the vigilance committee, there is no SP. Lordship will kindly take.
No,
page two.
Vigilance Committee, the investigation was done by one
SP.
Deputy Superintendent.
That
Judge
it was done by Inspector of CID.
Inspector
Single person, Malakar.
Malakar,
And
Jaduram.
he is not a part of the committee. Lordship will kindly take page 200.
No, obviously we know that. But it was argued that he reports to the SP. That was the argument. So if SP was in the know of things, then he being the judge of his own cause, that was the argument up to him.
That is too much stretching, but my submission is very clear. The vigilance cell consists of the DSP CID as well as Rajiv Borua and two inspectors. If Lordship is pleased to come to page 200 for a
Page
200.
Vigilance cell. He's not even a part of the vigilance cell.
Yes, the DSP is a part number 3 and two inspector 4 and 5. And Lordship will now come to page 159, where the SP CID Ulubari is the 4th member and joint director AR
159. Okay. Okay.
Here only the SP is there. Neither DSP nor inspector is a part of the company. This, in my humble size, a misconceived argument, Lordship, because there has to be some person. Here, there is a question of verification of the fake certificate. Lot of criminal angle is there. When that inquiry is to be done, Lord, suppose an inquiry was there. Police, the senior police officer's presence is very much helpful.
If you would have asked for an inquiry.
Yes, Lordship.
Or any incumbent.
Yes, if there is a fake certificate, forged document. Here it is a clean case. There is no allegation of forge. There is a mistaken in their judgment of the tribal compound. But here there is no allegation of fakeness or any forgery or any criminal angle.
Okay, understood.
So therefore, presence of the SP, because 4 and 5, the Supreme Court did not prescribe who can be. In respect of 120, there is a prescription. 4 and 5, there is the open area, it's a gray area. And on top of that, if they are agreed, on day 1 itself, jurisdiction question should have been raised. In their first reply, in their second reply, in their personal hearing, at no point of time, only at the stage of filing a writ petition, this question they have raised. That is too late in the day, in my humble submission. They have waived that. If the opinion had come in their favor, would they have raised this issue? Then they would have.
You mean to say
accepted
that they took a chance?
They took it. They availed it. And it was long, 4 or 5 years. Not that abruptly in a 15 days time, he could not have the opportunity. He gave his first reply on 31st August 2020. Second reply 21st December 2020. Then he appeared in the month of November 2020. All these 3 stages. And he's got this so-called notice on 11th of March. Constitution of the committee was the previous year, 2019. And my last line will be that he is not a layman. He is a lawmaker. So we have to look at from that perspective also. So this committee's constitution, that question was never raised. And there are series of judgments of the Supreme Court as well as of this High Court that if you are doubting the jurisdiction or regarding composition of the committee at the very first go, you have to raise it. That will should be a preliminary. You cannot have the cake and eat it too, Lord. And regarding all the other, which are basically the same thing, that cross-examination, etc., I have already placed my argument. And this Supreme Court judgment, they have referred to 1994, that Madhuri Patil I have placed already. They have placed two other cases, Chitra,
Yes.
2021, 880, and Civil Appeal Navneet Court, I have already placed now. That in Maharashtra's case, there is a separate law, separate act. And 90, this Adivasi Thakur. So that Chitra's case also, there is a separate law prevailing there. Rule 812 was there. Hmm. 2021 9 SCC page 811. J. Chitra versus District Collector and Chairman State Level Vigilance Committee, Tamil Nadu. What they are saying that one cannot reopen the investigation or the inquiry. Their submission was lordship from page para 10. Para 10 they have referred to. May I read it, lordship?
Yes.
In the instant case, the inquiry was conducted by the District Level Vigilance Committee, which was upheld by the community certificate, which has upheld the community certificate in favor of the appellant. The decision of the District Level Vigilance Committee in the year 1999 has not been challenged in any forum. The recognition of the community certificate issued in favor of the appellant by the District Vigilance Committee have become final. The State Level Scrutiny Committee did not have jurisdiction to reopen the matter, remand, or for place consideration by the District Level Vigilance Committee. The guideline issued by GO number 108 dated 12/9/2007 do not permit the State Level Scrutiny Committee to reopen cases which have become final. The purpose of verification of caste certificate by scrutiny is also to avoid false and bogus claim. Repeated enquiries for verification of caste would be detrimental to the members of scheduled caste and scheduled tribe. Reopening of enquiry into caste certificate can only be in case they are vitiated by fraud or when they are issued without proper enquiry. So their argument on the basis of this paragraph was that our second report could not have been done. My submission, it was not first report or second report, it was a composite report. And on top of that, there is a special government order 108, which powers the state level committee to reopen cases which have become final. If Lordship is pleased to look at our guidelines, OM of 2018, there is no such power. The Supreme Court judgment also, there is no such power. Supreme Court judgment is Madhuri Patil's case. So may I read paragraph 10, page 10 of my papers, which I have just given to the other side also. This will be my final submission. So have Lordship, para 10 of this paper, which I have.
Yes, yes, paragraph 10.
Paragraph 10 of the aforesaid judgment is not applicable in the case as because
We have read this.
Yes, Lord. So that is my case. To sum up, Lordship, all the grounds which they have harped upon, Lordship, are not at all acceptable in my humble submission because the complete facts were not placed. The law was not properly placed. We have placed whatever is available to us, Lordship. And if after their response, if anything is to be done for clarification, I am ready to do. Deeply obliged for giving me a patience.
Mr. Das, your road is limited.
Yesterday, I prepared. I thought I prepared all. And suppose I prepared 2024 judgment with my senior friend as basic. I thought this paragraph I'll place 15, 17, 18. Already he has placed. So let me now, I made a written note which will be convenient
Yes,
for the
yes,
court.
very
I'll
good,
give
very
to the
good,
other
yes.
side also.
Yes,
So this becomes very easier for the court. The other
Yes.
side. I'll give the notes to the other side. Your lordship, just I will not take much of the time. So it is my complaint, my lord. I made a complaint.
yes,
Now, my lord, basically challenge is 12/1/2014, which is a speaking order which is passed by the state level scrutiny committee. And it is the conclusive decision has been passed with a reason order. Now, what is most important, which the learned advocate general has also pointed out, which I have to reiterate and point out same thing, that 21/2024, my lord, passed by cancelling the scheduled tribe, this certificate that was never put to check.
that has been argued.
So
That
that's what I
that will
also
take care.
I also put a note on it. This was also never put to check. Same, I'll repeat the submission which is made by the learned AG, that has not been put to check.
Yes,
Now, my lord, for very quick, my lord, if you allows me, my lord, some list of dates I have given, we will not take much time to
no,
3
if
minutes.
those are already placed before this court by either of the parties, please, you can skip those because time is very precious. And probably Mr. Khurshid would like to have some rejoinder.
My lord will kindly see my submission, points
Yes,
of argument, page 5,
page 5.
page 5. This
Yes,
is the first point.
yes,
In the earlier round, the judgment order passed by Honorable Supreme Court, Honorable Court and the Honorable Supreme did not determine the petitioner as STP status. Because there are specific averment which they have made. My lord will kindly see paragraph 30 of the writ petition, at page 21. Kindly see para 20, page 21, my lord, para 30. If your lordship kindly take it. That the petitioner states that wherein the petitioner elected for member of parliament for so and so, the private respondent with another person file an election petition being election petition of Court Honorable Court challenging his social status and contending that the petitioner nomination paper ought to have not accepted by the returning officer for reserve constant to STP as he does not belong to Borough Kathari community. The aforesaid election petition was after trial finally disposed on 9/6/2017. Dismissing the same, the aforesaid judgment has reported against the dismissal order private respondent, along with another person approached the Honorable Supreme Court by special leave petition, which were registered as civil appeal. Honorable Supreme Court by order dated dismissed the aforesaid SLP number 10194 of 2017. My lord, if you see kindly 89, page 89.
yes,
That is reply to this so-called, we start at page 87. 87.
yes,
Kindly see at page 89. 87 is start. Para on the top.
Yes.
Furthermore, lordship got it. Page 89. Furthermore, another election petition being election filed by the company and another in Guwahati High Court, challenging my nomination paper numbers to hence as scheduled tribe candidate, challenging that I am not belong to scheduled tribe, Borough Kathari committee of the state. Aforesaid late petition was dismissed by judgment order by the Honorable Court and in the above complaint election petition prepared an appeal against the judgment order dated so and so. Honorable Supreme Court India being civil level which also stood dismissed. Now this is important. It therefore means my social status as a scheduled tribe Borough Kathari committee has been confirmed. It is not. I'll show it the judgment of the Honorable Supreme Court para 7. Kindly 122 kindly look into it. 122. You start at page 117.
I think Mr. Khurshid had explained this.
No, I think
Status will not be decided
No,
in the
no,
election
kindly-
petition. That
that's
is the
why
interpretation,
your
wrong
lordship-
interpretation, wrong.
Your lordship has put a query where it is. Kindly see para 7. Para 7.
Yes.
In a situation where there is no pleading challenging the validity of the certificate certifying the return candidate to a member of Borough Custody Committee, and therefore, only one paragraph. And therefore, the member of Borough Custody Committee, therefore, a scheduled tribe recognized under presidential order, we cannot find any fault in the order of this court. Neither is there any pleading nor issue framed with regard to competence of the authority issuing the certificate to act in the state manner ready to issue the certificate. When the election petition themselves did not challenge the validity of the certificate or the competence certificate, issuing authority issued the same, we do not see how the view taken by the so and so return can belong to so and so. That is the reason, my lord, 2013, 2019, we challenged this one. That's what I want to show it.
No, that is okay.
It is not a conclusive. It is not a
It has not
conclusive.
been argued that it is
No,
conclusive.
that's what they have stated here, my
They
lord.
have stated many things, but
No,
we
but-
will
but I have-
we'll only take care of those things which are
That's right.
relevant, which are
Yeah.
reasonable.
Yeah.
And it was
No.
clearly considered yesterday that the correctness of the certificate, for the mechanism laid down, that was not taken recourse.
Now, my
So
lord,
this is okay.
my lord will kindly now see my submission written argument C.
See,
Lordship, what is my notes I have given.
yes, please.
Note.
Hmm.
My lord, on 19/4/2000, respondent filed a complaint against the petitioner before so and so in the same year petitioner of preferred writ petition challenging the issuance of ST certificate by all of them so and so. The honorable court passed an interim order in writ restraining the issuance of ST certificate to committees not notify ST under so and so. Despite the operation order, the petitioner used his invalid certificate to contest the parliamentary election. According to respondent by file election petition before the challenge.
This you can
So
skip.
this
Just-
goes on, my lord.
Just skip.
Yes.
Skip. You're short of time. Just
Now-
skip this.
Thereafter, my lord, in view of the above of the Honorable Court Supreme Court, so I have read that, my lord, paragraph 7. If you please turn to next at page 7, D.
Yes.
Now, SLC's finding, next is, my lord. SLC finding is based on conclusive fact finding and after giving due opportunity as per Kumari Madriba. Now, my lord, learned friend has elaborately has argued this matter. This I also reiterate, my lord. This the procedure has been laid down. Madhuri Patil and all these procedures has been followed. Reasonable opportunity was also given to me also. It's not that opportunity was not given to me. Opportunity was given to both the parties. What I have heard, my lord, the learned AG has said that you have to demand. That demand was not there. That by reading of that Madhuri Patil judgment of 13.7. 13.7 paragraph, so I am not wrong. There has to be a demand. And the learned AG has also read his reply. His written reply, which was given before the scrutiny committee, clearly states a personal hearing, he wants that personal hearing was given. So my D argument, D, at paragraph, at page 7, all the procedure mandated in Kumari Madhuri Patil was followed. Now, my lord will kindly skip, my lord, para 18 kindly be looked into it, my. At page 9.
9, yes.
18, my.
Yes, page
I'll
9.
skip because all this,
Yes, yes.
I have mentioned it.
Mm.
What is the role of the SLC, how it has to be done. They have followed. See para 18, my lord. Therefore, the allegation of a petitioner that no opportunity is given to him to address everything wholly misconceived. The SLC is not an adjudicating authority like court of tribunal. SLC is an administrative body. The Honorable Supreme Court in case of Diaram, which my learned senior friend has pointed out, I think, it's not been placed. Yes, I'll just show this particular of the judgment. Only his remark has been made in Diaram. Now, you just read this, my lord. SLC is the administrative body. Honorable Supreme Court in case of Diaram so has held SLC is the administrative body which verifies the facts, investigate specific claim of caste status, ascertain whether the case type status claim is correct or not. In the present case, ample opportunity to provide the petitioner present his case and submit his document in support. Petitioner being a city member, so and so cannot be considered. What is the argument? Layman, he knows, my lord, he's an MLA, he's not a layman. See now, para 35 kindly be seen of the judge of the Arab. At 353 mile.
Paragraph?
35. What you got it, my lord?
Yes,
35.
just. Yes,
I don't know, I will not repeat, my lord, what he has, which this is not brought. The scrutiny committee is not an adjudicating authority like a court or tribunal, but an administrative body which verifies the facts, investigates into specific claim of caste status and ascertain whether the caste tribal status claim is correct or not. Like any other decision of administrative authority in order, the scrutiny committee are also open to challenge proceeding under 226. Permitting civil suit with provisions for appeal and further appeal would defeat the very scheme and will encourage the very evils which this court wanted to eradicate. As this court found a large number of seats of post reserved for the scheduled tribe were being taken away by bogus candidates claiming to belong scheduled caste and scheduled tribe, this court directed the Constitutional Scrutiny Committee to provide an expeditious, effective and efficacious remedy in the absence of any statute or a legal framework for proper verification of false claim regarding so and so. Entire scheme in Madhuri Patil, which will continue till a legislature concern makes an appropriate legislation in regard to verification of claim for caste certificate, issue of so and so, or in regard to verification already obtained by candidate who seeks the benefit or reservation, relying upon such caste certificates. Now, my lord, page 10, my lord will kindly look into it.
this case is of which,
It's
state?
2012.
No, which state?
My lord, this is,
Madhya Pradesh.
yes,
But in the latest judgment for the state of Maharashtra, the rules which have been
that's what my learned,
rules have been which have been
that has been framed.
rules also gives the power of civil court
Yes.
to the committee.
But here, in absence of rule,
yes,
we Madhuri Patil, that will follow.
in Assam, so far as Assam is concerned, AG has clarified
Yes, there is,
that there is no rule. There is an OM.
yes, OM.
There is an OM which is in consonance with the paragraphs of 13 of Madhuri Patil.
Right. And my learned friend already relied, AG has relied those paragraphs, which 15 is very important, that whether your lordship, that High Court on today can make a roving inquiry or not. That has to be your lordship. Yesterday I have heard that's what lordship has pointed out. To what extent our power under 226 judicial review so far inquiry is concerned. This is what it indicates
Yes.
in the 2024 judgment.
Yes. Okay.
And 2024 judgment also takes into consideration our diagram case. Para 18. Lordship can just note down. It takes into the consideration of the judgment at para 18. See at para 18, my lord, of the 2024 judgment.
Okay. Yes.
The lordship got it?
Hmm.
Para 18. Kindly see, my lord, it's mentioned. What you got it?
Yes, sir.
Yes. Eighteen kindly be seen, my lord. My learned friend has not read that. 18. As per the judgment, larger bench of the lordship is holding it.
Yes, yes.
This court in so and so, it revealed the court while answering the question of whether the civil court to observe the scrutiny committee is not the adjudicating authority like a court or tribunal. Rather, it is the administrative body which verifies the fact, investigating a specific case, caste claim, and ascertain whether the caste claim is correct or not. So, my lord, it was further so permitting this is what your lordship has seen. Para 19 has been read. I marked it, but I will not trouble your lordship because my learned, the AG has already read those paragraphs. All these paragraphs has been read. 21, 22, 23, I think has been read. 23 and 24 has been read. So I'm not troubling with your lordship with those paragraphs again.
Okay.
I prepared, but I thought I will not waste your lordship time.
Okay, okay.
Now, last, see, my lord. Detail I have mentioned, I will not read this, my lord. Page 10, kindly see.
Yes.
On a written submission on 10. Page 10.
Page 10.
Now, this is third last argument. The petitioner, by using the STP certificate dated so and so, has deprived those persons who are generally entitled to benefits according to the provision of law as well as constitution. This is what will affect, my lord. The genuine person will be affected, my lord, genuine person. This is our case, my lord. Why the genuine person should be deprived? Now kindly see these 2-3 paragraphs only. Petitioner has been elected so and so. Petitioner intends to once again contest for so and so purpose and reason. Judgment where to stop wrong gain, obtain position on the basis of false status, social certificate is the same as effect of depriving genuine settled caste and settled tribe by enjoying the benefit conferred to them by the Constitution. The STP certificate issued to petitioner by so and so cannot be concluded as conclusive proof of petitioner caste status. It is undisputed the certificate issued by so and so are subject to scrutiny by competent authority in accordance with guidelines passed by Honorable Supreme Court Kumari Madhuri Patil. It is dispersed of a spurious type have become a threat to the genuine tribals and a present a classic example of petitioner depriving the benefits given to the genuine tribes. So this is now, my lord, I'll just tell your lordship that last summarize, my lord.
Yes.
I've become fastest, my lord. Because the time is the important, which your lordship indicated. Otherwise, I thought that I'll argue. My lord, last, my lord, proposition. One, that the first inquiry found that the complaint of R8 was not genuine. And the second inquiry was initial video notice, that was the argument which is made by my learned senior friend or intimation. So very quick one line reply, my lord. I'll just give a note to it, which is fine easier. This is notice there is no second inquiry. And a report of 4/2/2020 that the lordship will find at page 74, I will not go through it, is continuation of the first report. That is page 63. And it is in accordance with Kumari Madhuri Patil. That's the first. In respect of the first, the argument which was made by my learned senior. Second, in respect of that, conclusion in the first report, that is 23/10/2019, is based on the letter of 5/6/2018 of the state which was withdrawn subsequent. The lordship has seen, I have read that there is a notification which was subsequently withdrawn. Now, there was, now, my lord, last, in so far as the first is concerned, there is no requirement to issue any notice so far as before the initiation of inquiry. Now, this is the first, the argument which is advanced from a learned senior. This is 1, 2, 3 is the reply. Now, second, the petitioner was not given due opportunity to present his case and was not permitted to adduce evidence. That is, no opportunity to lead evidence or cross-examine. This is the second. Now, my reply 1 very quick. I'll give a note, my lord. Proceeding before SLC are admissible proceeding as diagram. So, and do not contemplate trial like a civil court. Now, number 2, petitioner was given opportunity to file a reply, as well as additional reply and produce documents in this paper. And reasonable opportunity of hearing was given. His own application he has got for personal hearing. That was given. Due opportunity was given to him. Now he cannot say that opportunity was not given. Opportunity, in fact, was given to me. I was also present at the time of hearing. Now, now third, here last, petitioner has never sought permission for cross-examination or make any application seeking permission to adduce further evidence. The petitioner was permitted personal hearing, which your lordship will find at page 102. This is, my lord, this the argument. And third, I don't want to repeat about the SLC. It was not as per mandate provided under the Kumari Madhuri Patil case. That your lordship has read that it was fully complied. 13.4, how the constitution has to be, how it has to be constituted. 13.5, procedure has to be followed. 13.6 and 13.7, all was followed. So mandate of just quick, my lord, mandate of Kumari Madhuri Patil is not followed in the present case. This 4-line, my lord. 1, under paragraph 13.4, state government is required to constitute a committee for scrutiny of social status. Next, under paragraph 13.5, the manner of inquiry is set out. Number 3, under paragraph 13.6, sets out the procedure to be adopted upon receipt of inquiry report is laid down. And in the present case, the inquiry was conducted. A report dated 4/2/2020 shows compliance of Kumari Madhuri Patil case, considering the certificate of petitioner found to be not genuine. Therefore, the same was scrutinized and finally cancelled. Thus, there is a compliance of paragraph 13(7) as well. And the list of dates which I have given, my lord, that's limited to my case only. I have the list of dates. How it happened, my lord.
Okay,
After that judgment of the apex court, I file a complaint
right, right.
and all the procedures have been followed. It was forwarded to
Right.
vigilance. And my lord will, I filed on affidavit, my lord, on 8/4/2024, I file a affidavit in opposition on behalf of respondent number 8, which is on record, my lord, which the court has permitted.
Okay, okay.
I have filed that, my.
Mr. Gobe, what was the date of the office memorandum of the state? In terms of Madhuri Patil?
11 May 2018.
Hmm? One 150. 11/5/18. The procedure. 150.
Page 48.
Yeah, he's got it.
Yes, yes. One. What is 148? Oh, 148. Yes, yes, yes. Right, this one.
My lord, only your lordship will please note down that in my affidavit which has been filed,
Hmm.
in page 274, 5.1, para 5, the petitioner case is summarized. In para 5 at page 274,
Okay.
in my affidavit which I have filed. Now at page 275, to his case which has been summarized, at para 6 I replied. The contention has been dealt. Para 6 at page 275.
Okay. Okay, Mr. S. Thank you. Yes, yes, Mr. Khurshid. We hardly have half an hour's time.
Half an hour will be enough, my lords. I hope your lordships will bear with me. I have a very bad throat, so
Doesn't matter. Yes,
my
please.
voice will be a little hoarse. My lords, my puzzlement is having to reply to something that doesn't exist. We have said very clearly that the presidential order is the presidential order, and I can't even remotely claim to be within the presidential order other than by being a Bodo Kachari. So much effort was placed on that as though somehow I am seeking by a backdoor entrance into the president order. So I just want to make that clear, my lords. I think it was clear yesterday as well, but that is not the case.
That is clear to us.
I'm grateful.
That we're not good. That we're not entering into.
I'm grateful. I'm very grateful. My lords, and I have 5 or 6 points very, very quickly. My lords, my first point is about the constitution of those committees, subject to your lordships taking a view on waiver and estoppel, etc., that my learned friend has argued. But in the circumstances, what your lordships will finally decide, I will, of course, leave it to you. But my lords, the principle that will apply is the principle of likelihood of bias. Nemo juris in re sua, as your lordships observed, will apply not strictly where there is bias, but where there is a likelihood of bias. This is a principle well established now as far as administrative and constitutional law are concerned. So, my lords, I'm only seeking your lordships to look very quickly at the 2 committees that have been that are part of the process. My lords, 2 committees. I'll give the pages in which your lordships will find that.
Page 48.
Page 48, my lords, of the petition.
That is notification dated.
Yes.
My lords, the notification
Dated 11th May.
dated 11th of May 2018. I want to just point out, my lords, this is the scrutiny committee. Whatever 97 says, whatever 94 says, my lords, this is the scrutiny committee. And your lordship will see in the scrutiny committee, the first person who is also the chairperson of the scrutiny committee is the Secretary of Government of Assam. And the second person is the WPR, is the second person is the director, and third person is the director. I understand there are two directorates before the administrative reform. But the persons who are concerned with the committee for purposes of investigation under Madhuri Patil are number 4 and 5. Number 4 and 5, Superintendent of Police and the Joint Director, etc. Now, this was modified, my lords, to be the Superintendent of Police and such as many inspectors as are required. But these are the very departments here which will surface again.
Just can you repeat the last line, this modification part, what did you say?
Well, there was a subsequent notification by which they were allowed to take inspectors, any number of inspectors.
That is the vigilance cell. That is not this committee.
My lords, what the point I'm trying to make is that members are interchangeable. There are police members on the administrative committee, and there are administrative members on the police committee. That's what I'm trying to point out.
No, this point was sought to be clarified. In fact, this was a query made by the court that when there is a vigilance cell which is manned by police personnel,
that's right.
How come the superintendent of police can be a part of the scrutiny committee which examines its own findings?
Quite
that is
right.
your decision.
I'm so
answer was because we'll be soliciting a response from you. Answer was that vigilance cell, the contemplation of Madhuri Patil is not directly applicable here. We have a deputy superintendent of police who heads it, and he has two or three inspectors. And the investigation is done by the inspector, and it is headed by a deputy superintendent of police, who is not a part of the scrutiny committee.
Quite right, quite right. But the police are also part of the scrutiny committee, and that has come by way of, as my learned friend said, by the addition of 2 persons. It was originally 3 persons, all 3 civilian officers.
Yes.
It has now become 5 persons, and he has assumed that we can add 2 police officers to the 3 persons.
Yes.
Which I think is not called for, simply because the Supreme Court didn't warn that you shouldn't have police people here as well. I don't think it was fair on the part of the administration.
Now, is there any embargo or any hint by the Honorable Supreme Court that this committee?
There is no embargo.
Because one of the explanation given by the learned AG is that in case the question of further inquiry is required on the request of an incumbent, then such an inquiry can be felicitated if there is a police personnel there. That is an explanation. Whether we consider accept or not is a different matter.
That's an explanation, and it may well be a positive explanation.
Yes.
But what I am saying is, by virtue of the same department being in both places, when one department is actually given the investigation, to be it also in the judging of the investigation or ordering a fresh investigation, that would be violation of the principle of
likelihood of bias
and have natural. So, my lords, all these matters I will take to the extent to which the Honorable High Court can intervene and interfere. I'll take it all there. So one is about people from both departments in investigation, as well as the decision that is to be made on the investigation. So, my lords, this is one critical point of natural justice. My lords, that takes us to the next point, where they are talking about a single report. They keep themselves describing it as first report and second report, but they say that this is a single report, a continuation from first to the second report, to use the phrase that they have used. But interestingly, my lords, your lordships will find at page 201,
yes,
Of affidavit in opposition.
My lords, this isn't of the affidavit in opposition. It's my learned friend's of affidavit.
Yes.
Page 201. This is a corrigendum, which indicates that they've made a mistake about first report and the second report, or realized that they were making a mistake. So they have corrected it from the first report to the second report. And this is after several months, my lords. This is after several months. And I think this reflects upon how to look at the first report and the second report.
Okay.
Well, Lords, I had I'd indicated this yesterday, that as far as the first report, if we can, for the purposes of argument today, use them as first report and second report. As far as the first report is concerned, my lords, I make it categorically clear that the reasoning given in the first report is wrong. They couldn't have said he's a Boro Kachari on the basis of a notification that finally did not hold in front of this court. So they could not have come to a conclusion that he's a Boro Kachari on that basis. I make it very clear, very clear. However,
Yes.
however, my lords, if that was found to be a mistaken view taken by a junior official, if that was to be taken as a mistaken view, there had to be a fresh reflection on what needed to be done. And that fresh reflection would have been in either minutes of the scrutiny committee or in a directive of the scrutiny committee, whether you called it continuation or you called it another report. But they had to say, please ensure that this report is submitted to us in a proper manner, according to Madhuri Patil. There is no such letter. There is no such letter. It has been assumed, my lords.
No, Mr. Khurshid, factually, don't you think that their present this proposition may not be factually correct, because the scope or situation where a scrutiny committee would really look into a report would only come after soliciting your response by the director. That was not even done.
I'm even grateful to that, my lords. If it required
No, what he had submitted, that unless there is an application of mine by the scrutiny committee,
Quite
whether
right.
there is any further investigation required on the issue, then a
grateful.
second report could not have been done. That is your submission.
That was
But
my
that-
submission, but I'm looking at it from another point of view.
Please.
If the first report is found unsustainable and a second report is sought, or a continuation of the report is sought, should I not be brought into the picture to say the report that was given is not sustainable, and therefore we are putting you on notice that there has to be a further report?
No,
Now-
your role to defend yourself comes when? Was it during the preparation of the report?
My
Or
lords,
is it after a prima facie satisfaction by the director on the
Quite-
report and to issue a show cause to you?
Quite right. So here the director, without issuing a show cause to me, the director has rejected that report. And then if he was rejecting that report,
No, question will arise, will a right accrue? Because that was never communicated to you.
well, it was not communicated to me, but
See,
I
these
need
are internal matters. You may
all
be
right.
right in contending. If a right would have accrued to you by coming the report into the public domain or anything of that sort.
I take it.
Now
Well,
they say, and otherwise also the first report which was rightly contended is not in consonance with Madhuri Patil at all.
Quite right. Well, that's the only thing I ask. The only thing I ask your lordship, just consider it and leave it if it doesn't appeal to your lordship, is that the investigation is triggered off by some decision that is taken by the director or by the scrutiny committee. Something triggers off the investigation. Investigation is not suo moto. Investigation is at the behest of the director, who's part of the scrutiny committee, or by the scrutiny committee meeting together. They must trigger off an investigation. Now, in this case, assuming it's one report alone and not two reports, but what has triggered off the investigation, my lords? I ask myself. Something had to trigger off that investigation, and that paper might be a very critical paper as far as I'm concerned. It may be a critical paper, but this is only a point that I'm making in passing, my lords, because there are other points as well.
Just give us a minute, Mr. Khurshid.
Yes, my lords.
Where is the constitution of the vigilance cell?
The vigilance cell, your lordships will find at page 82, is it?
55.
At page 55, my lords.
55. Okay.
At page 55.
Just a minute.
This is the point I made to your lordships, that the first two civilian officials should not have been part of this committee. They couldn't have been. In Madhuri Patil, they couldn't have been. It's another matter if two more people are joined to the scrutiny committee and there is no clear embargo, and therefore they bring in police people. That's a different point, glass half full, glass half empty. But here your lordship will see that there are two civilians. Now, my lords, I will admit to your lordships that all these issues were not brought up at that stage, I must admit. And they're constantly saying that the lawmaker should know all this. My lords, if lawmaker knew what the law is, we would all be a happier nation. If I've been a lawmaker myself, and despite being a lawyer, sometimes I didn't know what law I was making, my lords, in Parliament. I don't mind admitting it. But here, my lords, the issue is that two civilians travel to the committee. What is the impression that this gives? And I do believe that is the likelihood of bias.
I'll just try to get a clarification. If you have page 55. Page 55.
Yes, my lord, this is page 55.
55 is the vigilance cell. It's nothing to do with the committee.
No, it's the vigilance cell.
Vigilance cell.
Madhuri
Okay.
Patil.
Madhuri
Patil does
yes,
not.
vigilance cell.
Civil.
Not the actual
Yes.
SLSC. Now you come to 148, the office memorandum which is prevalent in the state of Assam.
That's right.
148. And since this is the settled position, which is not subject matter of any challenge, so we'll go by this OM. This at
We'll go by
148, 11th of May 2018.
Yes.
We just read the first two paragraphs. Vigilance cell are to be constituted at each of the directorate, so and so, with such number of police inspectors as required, so and so. The vigilance cells are self-function and control under the SLSC. Number 2, on receipt of the reference, the inspector who will be designated as a vigilance officer shall go to the local place of residence and make all these inquiries, which is contemplated or directed under the Madhuri Patil's directions, guidelines. Then 3, the director concerned on receipt of the report from the vigilance officer, if he found the claim for social status is found to be not genuine, doubtful or spurious, or false, or wrongly claimed, director concerned should issue show cause notice supplying copy of the report to the vigilance officer to the candidate by registered post so and so. So the first, whether it's a first report or second report, your right will germinate only when you get a show cause.
Quite right. I can
Prior
accept.
to that, what internally was going on perhaps will not give you neither give you any right nor extinguish any right of yours. Because
That's
you are
right.
given an opportunity to show cause against the findings of the vigilance officer.
Once that comes. However, when I show cause, I can go back to see how this is being triggered. As your lordship sees here, on receipt of the reference, the inspector who will be designated, etc., shall go to the.
You could definitely take a ground that there was initially an initial report which perhaps was in your favor, but whether that report, why
But
is
I'm
it
not
not?
taking that. My lords, I'm not taking that. My favor, I've already jettisoned. It was in my favor. All I'm saying is here, the receipt of a reference, the inspector will begin his work.
Correct.
Reference by the vigilance committee or reference by the scrutiny committee, I ask myself, who gives this reference?
So this reference, perhaps the role of scrutiny committee will only come when when the director finds that there is materials in the report and your response is solicited that this is a report against you.
I take it. So this is not relevant really, as your lordships now
That is
feel.
what we are thinking. We are just thinking aloud.
I understand. So this is no concern of mine yet. But when I get a show cause notice, then I can fructify whatever rights I have to say this is went wrong, that went wrong. So I have no problem there. Your lordships may take it at that point. Now, my lords, there is an argument that is an important argument that was made, And that argument was made about the intention to legislate Saranya Kachari as part of the list of tribals. Your lordships were repeatedly told that this came and this couldn't get through, is still pending, etc., etc. Now, my lords, this is what I call jurisprudence of the concept of the original intent. Your lordships are aware. Your lordships are always told to interpret legislation. What was the original intent is seen for interpretation. Although it's controversial, some people have different schools, etc. But this original intent is being used in an argument against me, that because they had an intent of making Saranya Kacharis tribals, therefore, you being a Saranya Kachari are no longer a tribal since that legislation didn't go through. But I'm not relying either on that legislation or on Saranya Kachari at all. So I want to make that very clear.
That you have made it clear yesterday itself.
I'm very grateful.
Your certificate says that you are a Boro Kachari, and you are
That's
speaking that you are a Boro Kachari.
That's right.
Your
That's right.
surname of Saranya will not be a determining factor to come to a determination regarding your social status. That is
That's
your
right.
argument.
That's right. I'm
That
grateful.
we have.
I'm grateful. I'm grateful. Well, it's three one-liners. One issue was when did I get the letter, the show cause, and why did I reply in the show cause and then ask for another reply? This is only a factual thing. The show cause was sent to me by the director, as is the right thing to do. I assumed that this was about the 2014 controversy, and therefore I replied to him. When I realized it is actually the committee,
No,
then
that we are not finding fault at all. You are at
all right.
liberty to give a second so cause. They had accepted it.
I'm grateful.
One thing which is slightly troubling us is there is an argument by you that the speaking order, the impugned order, does not contain reasons on its own. No independent
That's right.
discussion. What do you say on that?
If your lordship just give me 2 minutes, I'll come to that. I'll come to that in 2 minutes, Mullah. Just another two liners were that there's no challenge to the confiscation and the cancellation order.
Oh,
Mullah,
yes.
very clearly, there is no challenge for a variety of reasons. One reason was that if we were being short of time for elections that were looming, if I had gone in for amendment of the constitution, of the amendment of the writ petition, there would have been replies and counter replies, etc., and I would have lost the critical time that I had. And therefore, I've relied on the argument that if the root cause goes, automatically whatever relies on that root cause will follow suit. There will be no problem. And in any case, I've said that any subsequent order also should go. Now, my lords, a judgment was cited by my learned friend 2011 6 SCC 595, paragraph 18. But that judgment, my lords, I think can be distinguished very easily because there the question is that the root cause was not challenged. And that was the decision of the cabinet that had not been challenged, and therefore the Supreme Court came to the conclusion if you don't challenge the root cause, then how can you rely only on challenging something subsequently? So that judgment, I think, is very clearly distinguished, my lords. Yes. My lords, then the show cause for the personal hearing, that's critical because question was asked. My lords, if your lordship will just recall Madhuri Patil, I don't want to take your lordship there again. Madhuri Patil says that if you ask for a personal hearing, you will be given a personal hearing, and then your lordship will see it says personal hearing and inquiry and the right to adduce evidence. Now, is a right to seek personal hearing and a right to seek an inquiry two separate things? I ask myself. Well, inquiry is an integral part of what the committee is supposed to do, is to inquire into the facts that are placed before the committee by the vigilance cell. Inquiry is essential. My lords, even if I hadn't asked for a written, if I hadn't asked for a personal hearing, the inquiry will still have to be done. The inquiry will have to be done in absence of any personal hearing. Inquiry cannot be dispensed with. So is the adducing of evidence to be linked with inquiry, or is the adducing of evidence to be linked with the seeking of personal? If your lordship will just see Madhuri Patil for a moment, because this is this is a very, very sharp point, and this is Madhuri Patil's 13.6. In the middle of that, if your lordships have. May I read it to your lordships?
Just a minute. We'll have, don't worry. Madhuri Patil. Yes, paragraph?
Paragraphs 13.6. My lords,
Yes.
curiously, we are both relying on this. As your
Hmm.
lordships have seen, we are both relying on this. But this is the interpretation that your lordships will put in it will be important. So, my lords, around placetum F, in
Yes.
case
Yes, candidate.
candidate seeks for an opportunity of hearing and notice and claims an inquiry to be made, in that behalf, the director on receipt of such representation reply shall convene the committee and the joint additional secretary as chairperson, who shall give reasonable opportunity to the candidate, parent, guardian to adduce all evidence in support of their claim. Well, as this follows, if one sees how it follows in English, then all you need to do is to ask for an opportunity to be heard. And that opportunity to be heard leads to for requisitioning the committee, and the committee then giving reasonable opportunity to the candidate, the parent, the guardian to adduce all evidence in support of their claim. So, well, the argument that was made that I didn't seek adducing of evidence is an argument which I believe, with great respect, does not hold. And I have another argument to support this, my lords. And my other argument to support this, if your lordships will turn to the show cause itself, which is at page 82. Your lordships have page 82.
82, yes.
11/3/2020. This is the show cause. What is that question?
Yes. Yes.
Oh, my lords, I've just looking at whether this is the relevant portion or the OM that your lordships were looking at. If your lordship will go to the OM, this is the
Yes.
If your lordship will look at paragraph 6 of the OM, so I'm relying on at page 49.
149.
Only for
Only 49.
Only 49, my lords.
Okay. Okay.
But this is only on the day of the hearing, my lords, paragraph 6.
Yes.
On the day of the hearing, the committee shall examine all documentary evidences in support of the claim and record the hearing, so that there is no doubt about what happened that day. After giving such opportunity, the committee shall make an inquiry as it deems expedient and consider the claims vis-a-vis the objections raised by the candidate or opponent as the inquiry report and pass an appropriate order and brief reasons in support. So, my lords, 2 or 3 phrases here. Brief reasons in support, make such inquiry as is feasible, and after giving the hearing. So, my lords, obviously, after giving the hearing, only the opportunity to adduce evidence will come, the opportunity to cross-examine will come, and that follows from Madhuri Patil. It clearly, as I showed to your lordships, that all follows. And it can't be that they have to do an inquiry and nothing of that inquiry surfaces as far as the speaking order is concerned. And when, with great respect, my lords, I could not convince the division bench about whether it was a speaking order or not. I take it upon myself that it must have been my inability. But may I just take your lordships to the speaking order, and that will make it very clear.
Since we are on this point of constitution of the committee at page 48,
My lords.
48. Please read this with 148 also.
Read this with 148.
Page 148 of the office memorandum of the same date.
Yes, my lords. What?
And this office memorandum at 148 is the prior office memorandum before, because if you see the number, it's 152.
152.
And this at page 48 is 153.
Quite right.
And if you see the narration of 148, the first paragraph itself.
In pursuance of
accordingly, the following instructions are issued for further simplification of the procedure for dealing with the matter relating to fake caste certificates. So this is the detailed procedure which has been laid down.
That's
and
right.
We have just compared with the directions in Madhuri Patil. It is verbatim.
Well, it's verbatim, except to the extent that I pointed out to your lordships.
Yes.
That one single line is very clear. Now,
Yes.
whether this is intentional or it is unintentional, when you transfer a judgment into a OM or into a legislation or rules, sometimes the gist is lost, sometimes unintentionally. But what would finally prevail, my lords, is the Madhuri Patil judgment. It cannot be diluted in any form by anything that the government does, unless government shows that it has the right to dilute it in some form or the other. As your lordships knows, we can't possibly depart from your lordship's judgments and dilute them.
Okay, regarding the reasons part.
Then, my lords, the reasons, if your lordships will now come to the
impugned order.
Impugned order, the impugned order. Where is the impugned order? Well, lords, the impugned order your lordship will find at 111.
111, yes.
Annexure 27.
Yes.
12th of January 2024.
Yes.
My lords, the speaking order begins with the recital of all that has happened. Nothing, no cavil with anything there. Here also, if your lordships will see, on page 112. On page 112, the first line itself. The first line itself is still talking about first report, which should be second report. If we now go by what they are saying, then it should be second report. And then after the recitals are over, after the whereas are over, including saying that the legal department decided not to give them any opinion because the matter was pending in court, then, my lords, your lordships will see this is a repeat of the report. Number one, STP certificate was issued in the name of so-and-so, etc., etc. Number two, records obtained during course of inquiry reveal the parents and grandparents of Sri Nabha Kumar Saranya were late so-and-so and so-and-so. Then, my lord, about the sister, Srimati Dipandita Saranya, sister of Sri Nabha Kumar Saranya, stated that she has an STP certificate and she and her family belong to Saranya community. Now, I've said earlier, my lords, consistently with what our argument is, that Saranya community is not Boro Kachari tribals. Saranya community are all those who become Saranyas. But here she has specifically said that I have an STP certificate.
Yes.
This is Roman 3, that I have an STP certificate. No further inquiry is made. No attempt is made to get a copy of that certificate and to investigate whether that certificate was of any use. Then, my lords, the next is 5, certificate of discharge from the army, where he's called an Assamese with a subclass of Das. Again, not conclusive one way or the other. Then, my lords, there are statements by Shri Raman Rabba. These are people of other tribes, Rabba tribes. Then, my lords, 7 is the NRC legacy data. 8 is the land chitta record, etc. And then, my lords, according to the ILS certificate 9 and 10 about the parents, etc. My lords, nowhere beyond the recital of what facts have been given to them, nowhere is there even a whisper of a discussion about what this means and what has been said in reply to this. What has been said in reply, my lords, your lordships will find in detail. I have given a reply. We may not have produced every evidence because we were not producing evidence, but we've produced in detail. Your lordships may just note this at page 92.
Yes, 92.
92, your lordship may just note para 4 onwards. I've given a detailed reply. It could have been rejected. They could have said this is not acceptable. But I think they just haven't done the exercise where they would reflect on each reply, come to a conclusion that this reply requires evidence, this reply can be rejected outright, etc. My lords, as your lordships often do. And then, my lords, if your lordship will see 7, Roman 7. Second paragraph, I say that the statement of Raman Rabba, Annexure 5 of the inquiry report is totally incorrect, concocted. First of all, he is not permanent village headman, village Digjalpur, so he has no knowledge and the social status of our villagers. Due to death of a former village headman, he was allowed to discharge the responsibility of the village headman of our village, Digalpur, almost for 1 year. In his statement made before the investigation officer, he said, my father died in accident while serving in the Assam regiment, which is not correct. In fact, my father died in 1992 after 12 years of his retirement. Further, regarding Koch, I say that I and my ancestors are not belonging to Koch community. Even we do not have any marital relations with members of Koch community. Now, all this had to be done, my lords, in the process of Madhuri Patil affinity test or whatever else was to be required. All this has to be done. Now, it hasn't been done, and there is no go back to the. Your lordship will now come back to the speaking order. None of this is done. They've only repeated what has been said, suggested. And then your lordship will see the bottom of paragraph 9. And then, my lords, your lordships have never accepted such reasons. Whereas the SLSC committee, after careful perusal and examination of the written statements and documents, certificates, etc., submitted by Shri Nava Kumar Sarania and Shri Janaklal Basumatri, and the report submitted by the Vigilance Committee, is of the view that Mr. Nava Kumar Sarania is not a Boro Kachari. My lords, with greatest respect, administrative order or non-administrative order, but your lordships have insisted that any decision that has an impact, far-reaching impact on the lives of people, has to have an element of natural justice, and it has to have an element of reasoning. There is no reasoning here at all. I would be happy if somebody showed to me one line of reasoning, my lords, in this, even one line of reasoning. There's no reasoning, it just goes out. And I put one thing, my lords, I think I put one thing to your lordships as as an issue of national policy or an issue of policy of reservations. My lords, in your lordships, if your lordships were to decide against Mr. Sarania, and Mr. Sarania's certificate goes and is confiscated, there is no indication of what Mr. Sarania can do from the next day. There is no estoppel against this. There is no finality. He could go with all his evidence that he didn't have, and he could go back to the committee and say, please rejudge me. And the committee can't say that, no, this is res judicata. They can't say we are administrative and then say this is res judicata. Well, for all times in his life, he can't lose his status. All he will lose, perhaps, is his chance to be an MP again. But he would not lose his status. If there had been a proper inquiry, then there would be satisfaction on knowing that that proper inquiry, assisted or not assisted by adducing of evidence, that proper inquiry at least has given a quietus to something that requires a quietus. And as your lordships know, the Supreme Court has said that there can't be a regurgitation and reopening of these things, because it creates a sense of disquiet in society. So, my lords, that's my last and one last point. What? Well, there's now two things. I don't know if your lordships is in a position to actually examine this, but we do have a certificate of 1923, 2023. We have a, no, it can't be 23, 1920. Okay, maybe 2023.
Oh, sorry, 73.
73. We have a certificate of 8/10/73, but I don't know, my lords, in the rules whether your lordships can make an exception and look at it. Your lordships asked me that question, so we did the best we could to find the certificate. Your lordships may take a copy and then take a call on it as your lordship proceeds. My learned friend will give a copy of this, my lords. Right. Lastly, my lords, and this is the crowning part of the argument.
What is this?
This is relative of the grandfather.
My lord, this is a relative of the grandfather of this person, but of course I do realize this is very inconvenient at this time for your lordship to be looking at this. But because your lordship asked me that question, I managed to procure this. Because the issue of verification, whose grandfather, etc., this is a more complicated exercise than the legacy data. What is his name?
Medini Deka. Medini Deka.
Your lordship,
Who is this particular gentleman, Medini Deka?
Medini Deka, my client tells me, was a close relative of his grandfather, But at least it shows one thing, my lords. It shows that the names are not conclusive.
That is an accepted position.
Well, your lordships,
Surname hardly will make any difference to the caste factor.
your lordships have taken that view.
So yesterday we had put a question to you that which has been also highlighted today. The caste certificate was issued for the first time in the year 2011.
2011.
When your client was around 40 plus.
Please.
He had passed his matriculation in the year 1982, I think.
That's right.
From either his, whether he's employed or other business purpose. If you are belonging to a particular scheduled category, then you get certain benefits. Either him or his brother or sister or anybody. Prior to 2011, is there any material which you could have relied upon? Even if you have not produced at the time of your show cause, even now, the statements by your sister is post the date of the show cause.
That is post, but it may have some probative value if they inquired as to say, where did you get this certificate? My lords, my only argument about this is that in 2011, when I got the certificate, in 2011, it was given by an authority that is not being challenged at any level.
That we're not questioning. That is not even the subject matter. Whether that particular organization has the authority to issue such a certificate. But it is a matter of fact that 2011, the certificate by an authority was given.
That is
all
right.
All these years, there was no certificate in your name.
Before that,
and to regard you as a belonging to a particular category, in absence of a certificate, you don't have that right.
Right. In the absence of certificate, I don't have that right.
2011, the right has accrued upon you.
That's right.
And prior to that, it's not a matter that young boy coming to the court just after his matriculation. He was 40 some years. All these years, is there any explanation that he was not in requirement of such a certificate? Or he
My lords, he was in 20, he was 25 years old, and he was associated with organizations where certificates were not necessary, and therefore he never felt the need. Yes, that's the reason. Your lordships are smiling. Well, lords, but I'm just giving the kingpin of the argument, which is a judgment. Lastly, is a recent judgment, Civil Appeal 7939 and 7940 of 2022. This is Union of India versus Subrata Nath. I think, my lords, this is the Chief Justice's own judgment. Paragraph 15 and 22. Just show that very quickly to your lordship. Paragraph 15. There, of course, the proposition your lordships have been repeatedly told. Paragraph 15, it is well settled that courts ought to refrain from interfering with findings of facts. Paragraph 15, my lords. Internal page. It is well settled that courts ought to refrain from interfering with findings of facts recorded in a departmental inquiry, except in circumstances where such findings are patently perverse or grossly incompatible with the evidence on record based on no evidence. However, if principles of natural justice have been violated or the statutory regulations have not been adhered to, or there are malefices attributable to the disciplinary authority, then the courts can certainly interfere. Now, I have not claimed malefices, my lords, that your lordships have noted, but all the other matters are there. Natural justice and based on no evidence, and indeed here, no speaking order itself. So therefore, your lordships will be entitled, despite the caution that the Supreme Court has given. Next paragraph.
22.
Then, my lords, is paragraph 22. It's a repeat of the same thing. My lords, one last judgment, if your lordships may note. Ravindra.
Yes.
My lords, this is Civil Appeal number 5798 to 5799. Bachaj Nahar versus Nilima Mandal, paragraph 11 and 12. My lords, along the same lines as to when the courts can intervene or interfere, etc. And here, my lords, on page 9, the page 9 at the bottom, the honorable judges have quoted Bhagwati Prasad versus Shri Chandramaul of AR 1966. Then, my lords,
Which paragraph?
My lords, this is paragraph 11,
11.
and it refers to the point about pleadings. My learned friend had emphasized the pleadings a great deal. So if your lordship will come to this, where Constitution Bench is cited by them, at the bottom of page 9.
Yes.
If a plea is not specifically made out and yet it is covered by an issue by implication, and the parties knew that the said pleas were involved in the trial, then the mere fact that the pleas are not expressly taken in the pleadings would not necessarily disentitle a party from relying upon it if it is in the satisfactorily proved by evidence. The general rule, no doubt, is that the relief should be founded on pleadings made by the parties, but where the substantial matter relating to the title of both parties to the suit was touched, tough indirectly or even obscurely in the issues, and evidence has been led about them, then the argument that is particular matter is not expressly taken in the pleadings would be purely formal, technical, and cannot succeed in every case. Well, lords, of course, this is a circular argument because your lordships are deciding whether there was evidence or not, whether that evidence was considered or not. And I'm saying that the evidence was not considered. So it's a circular argument in saying that the pleadings, even where there is no evidence, and if there are no specific pleadings, you can still rely on the Supreme Court judgment, my lords. My lords, I'm very, very grateful for your lordship's patient hearing.
We conclude this
My lord, yesterday one judgment has been referred. I failed to provide a copy.
which one? Yes, please, which one?
My lord, the House of Lords judgment, my lord. Yesterday in the notes, it is referred, my lord.
Yes, what was the proposition?
My lord.
Even in cases of civil and criminal cases, cross-examination.
All of the issue of cross-examination, we'll give a copy to my learned friend.
No, I think he's handing over.
Yeah.
Yes.
It's the duty to be fair.
Para 64.
But as Secretary of State for
That's,
whom?
that's right. Para 64, my lord.
Yes, yes, we have noted.
Great.
Natural justice, duty to act fairly.
Grateful. My lords, can I just be a little upfront and flag the point that, my lords, my last date, if at all I succeed, my last date
19th.
is 19th.
That is the reason we are giving priority to your case.
I'm grateful. I'm very grateful, my lords.
18th we'll try to deliver.
Deeply obliged.
Deliver. In case there is a difficulty with this bench, we'll get it pronounced by some other bench. But we'll make an endeavor to have it on 18th, not on 19th.
Deeply obliged.
This side or that side?
Not.
Okay, thank you, Mr. Koshy.
Thank you.
Heard. 3. No, in continuation of yesterday's hearing, Sri D. Saikya, learned AG, has concluded his arguments, followed by the arguments by Sri D. Das, learned senior counsel for the response number 8. Full stop. Sri Khurshid, the learned senior counsel for the petitioner, has made his rejoinder argument. Full stop. Online. Full stop. Para. The hearing is concluded and judgment is reserved. Okay. Wish you all a very happy Bihu.
Time to lordship.
With a good homework, Lord.
This is what is called passing the burden. Somebody has to take the burden. Okay, let us see.